What up, sir? What up, sir? What up, sir? Court officer? Court officer? Court officer? Sir, court law number 27.
Sir, 27 sir, total no?
27 ಅಲ್ವಾ?
Is correct.
ಹೌದಾ? ಥ್ಯಾಂಕ್ ಯು. ಅಷ್ಟೇ ಕೇಳ. ಓಕೆ ಓಕೆ ಓಕೆ. ಸರ್ ಹೆಗ್ಡೆ ಅವ್ರೆ,
ಏನ್ ಸರ್?
ಟೋಟಲ್ 25 ತೋರಿಸ್ತಾ ಇತ್ತಲ್ಲ, ಇದೇನು ಕರೆಕ್ಟಾ?
ಹಾ?
ಟೋಟಲ್ 25 ತೋರಿಸ್ತಾ ಇದೆಯಲ್ಲ, ಕರೆಕ್ಟಾ ಇದು?
ಅಲ್ಲ 27 ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ನಾ ಈಗ ಕೇಳಿದೆ.
27 25 ತೋರಿಸ್ತಾ ಇದೆ.
ಏನು ನಂಗೆ ಗೊತ್ತಿಲ್ಲ, ಸಾರಿ. 27 ತೋರಿಸ್ ನೋಡಿ, ಪ್ಲೀಸ್ ನೋಡಿ, ಪ್ಲೀಸ್. ಹಾ 27 ಅಲ್ವಾ ಮೇಡಮ್? ಕೇಳಿ ನೋಡಿ ಮೇಡಮ್.
You move it on Monday, Tuesday. Why are you moving today? Then you will make the submission, the matter is not listed. So correct, it's a date which is very away from today. 11th is quite far. So take a chance, you move it on 9th, 10th. Yes. Correct.
2020, assignment, page number 5, serial number 25, 23. Serial number 24 to 28.
25.
ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ ಐಟಮ್ ಇದು ಮೆಲಾಟ್. ಇದು
Serial number?
ಅಲ್ಲ, ಲಿಸ್ಟ್ ನಂಬರ್ 1 ಮೆಲಾಟ್.
Yes, there's only one list.
One.
Second list.
ಇಲ್ಲ.
Sir, yes.
Serial number 28, I may be excused. It is posted for brief that I want to, because in my absence, the documents were received when I was abroad. I have to produce it for only 1 week time, only 1 week, nothing more. Serial number 28, 3 matters.
Okay, the petition is of the year 2012.
Yes, I do consider that is the wrong, because I was abroad, therefore it was happened. I may be excused for it.
As a last
chance, 11th.
As a last chance, at request of the petitioner counsel, is this matter on
11th.
Number 25. Next week.
Why?
Next week.
Okay. You are Mr. Mohan Bhatt, right? Then you are there before the court. What is the reason for seeking adjournment? Okay. Just matter of right. There's no matter of right for adjournment. There should be some reason, right? In beda, you come. Next.
Page number 7, serial number 29 to 34.
My lords, serial number 34. Oppose any adjournment, my lord.
My lord, there is one more connected case. My other counsel is having the knowledge of other connected case number.
Yes.
Let both the cases be listed together, my lord.
Is this petition along with? Next week.
Well, my lords, what is the connected matter? I should know.
No, filed by one Venkatappa. Another party to the proceedings.
He is a party in this proceedings, Venkatappa.
Yes, my lord. One of the respondents
As
is
respondent number?
Venkatappa.
As respondent number?
I am respondent number 1 and 2, 2, 3, my lord.
On the very same land, LR application is filed by Venkatappa. Is respondent number 2, my lord. Respondent number 2.
On Wednesday. Next Wednesday.
Much obliged, my lord.
Ah, yes. Yes, we will hear this matter. Correct, only because of your informing, should the court grant you time, because on the last occasion, this matter was heard for some time. And then at your request, the matter stood adjourned for today. Ah. Ramesh Kumar, Learned Counsel so and so submits that the counsel on record's father has been hospitalized and he's got inconvenience to appear in this matter today. At request, list this matter on Wednesday. So such things we should not say in case.
Page number 8, serial number 35 to 39. Page 9, 40 to 45.
40, eh? Ah. Ah. What is the personal convenience? You are already there before the court. Satyannahalli, Learned Counsel submits that he is unwell. At request, list this matter next Wednesday.
Page number 80, serial number 46 to 43.
46.
Ah. Hmm.
Defensible scheme at is not.
Notification, huh? That notification is challenged. On this matter after 2 weeks. At-
47.
Ah. When you are making submission on behalf of Harish Bhandari or the petitioner? He can, ಅವರೇ ಹೇಳ್ತಾರಲ್ವಾ? ಹೌದು. You are not in receipt of the papers, Mr. Harish Bhandari. You have not received the written petition. Harish Bhandari, Learned Counsel, for the respondent submits that he is not in receipt of the written petition papers. Petitioner counsel to serve the petition papers on Harish Bhandari. Please list this matter on Wednesday. Wednesday, na? Ah.
Serial number 15.
26. Huh? 19. 19th is a Thursday. 18th. Then 25.
Serial number 50, my lord.
25.
Senior has been engaged, is not available today. When you have to 18th, my lord. 49, 50 and serial number 3, all corrected.
Mr. Parasara Kumar. This matter was, interim order was granted by this court and any day anmale this, we are ready here all the time. We sit from 10:30 to 5:30. Then what remains in the cause list today? All matters are of Parasara Kumar. Huh? ನೀವು objections ಹಾಕ್ಬೇಕಾ? ಅಲ್ಲ ಒಂದ್ ದಿವಸ ಹೇಳಿ the date of your choice, we will dispose of on that day. When 11th
Senior is available on 18th.
on 18th. 18 senior ಅವರು ನಿಮ್ ಪರವಾಗಿ ಬರ್ತಾರೆ. Yes. ನೀವು ಹೇಳಿ date. 17th. Yes, interim order granted earlier is extended to the next date of hearing. ಎಲ್ಲ ನಿಮ್ದೇ ಇದ್ದು ಇವತ್ತು. Connected, will connect all these matters. Yes. Which has to be connected? Writ petition, ಇದು serial number 3 ನಲ್ಲಿ WP 23565 of 2024.
Subject number changes.
ಇದು
Subject number different.
ಅಲ್ಲ ಬೇಡವಾ? It's not to be connected? ಅಲ್ಲ ಆಯ್ತು ಬೇಡ ಕನೆಕ್ಟ್ ಮಾಡಬೇಡಿ. List this matter on 17. Interim order granted earlier is extended to the next date. ಆಯ್ತಾಯ್ತು 3 ನಲ್ಲಿನೂ yes.
Page number 11, serial number 8.
Next. Fresh matter.
This one.
ತಗೊಳ್ಳಿ tomorrow. Yes, Mr. Shekhar. ನಾವು ಕೊಡ್ತೀವಿ ನಿಮ್ಗೆ ಬಲರಾಮ್ ಜಡ್ಜ್ಮೆಂಟ್. This matter on Monday. ಅದೇ ಹೇಳಿ ನೀವು ಇವತ್ತಿನ ದಿವಸ ಹಾಕೊಂಡ್ರ ಮತ್ತೆ why should you approach? They should approach you. Request of the petitioner counsel, this is not after court. Yes, it's a say.
Number 1.
Yes, on the same matter, stay of the impugned order. Why 50%? Entire, no differentiation between any of the. Irli, you deposit entire compensation amount as awarded by the trial court. If you merchant purpose to this. Yes, Mr. Shant Kumar. Objections, huh? At 2:30. Now, if it is within 90 meters. EDWD. Affidavit in purpose. Then see, they are giving an affidavit or memo. Memo, na? This court directed you to produce that? Illala? So your statement of objection states that the location of the premises is within 90 meters. State SCGP for the state submits that the proposed building is within 90 meters from the state highway and has filed objections, statement of objection to that effect. But however, the supporting documents pertaining to the contentions raised by the state was not filed. And the state SCGP submits that the same would be filed in the counter by serving the copy upon the petitioner. List this matter on 18. 18 meters ಒಳಗಡೆ ಇದ್ದರೆ ಬರೋದೇ ಇಲ್ಲ. Yes. Thus connected petition survive. Petitioner memo is filed seeking to withdraw of the writ petition. Memo is taken on record. Petition is dismissed as withdrawn. 4.1 nulli. With liberty, since the writ petition has been filed, challenging the order passed on the representation. Connected writ petition has been filed, challenging the order passed on the representation. Yes.
Okay, how the government works, how these people will have to be dealt with.
Because the petitioner is a partnership firm. It has two licenses, one for CH-7 and CH-9.
Since when?
For several years. Because one of the partners, Meenakshi, died on 6/1/2024. My lord, may please to consider the date. Annexure C is the death certificate.
When did she die?
6/1/2024.
Yes.
Soon after the death was intimated as per Annexure D, page 35, on 14/2/2024.
14 to
2024.
you inform the authorities.
Authorities.
You inform the death of Meenakshi.
Deputy Commissioner of Excise, Kodagu district.
Extras.
D and E, because in the two licenses, the same, all documents are in my duplicate. Page number 35. ಈ ಮೂಲಕ ನಿವೇದಿಸಿ ಕೊಡುವುದರಿಂದ ನಮ್ಮ ಪುಷ್ಪರಾಜ ಭಾರತೀಯ ಹಿರಿಯ ಪಾಲಕಿ ಮತ್ತು ಮೀನಾಕ್ಷಿ ಚಂದ್ರಶೇಖರ್ ಶಿವಶಕ್ತಿ ಇವರು 6/1/2024 ಮೃತಪಟ್ಟಿದ್ದಾರೆಂದು ತುಂಬಾ ವಿಷಾದ ಸಮಾಧಾನಕ್ಕೆ ತರುತ್ತೇವೆ.
You inform the
Deputy Commissioner of Excise, the concerned authority in the district. Normally, my lords, in law, any law that's a 90 days time to bring the legal acts on record if it is a legal person. Excise department has made an unwritten procedure of 45 days time. This is done within that 45 days time. And thereafter a partnership is also reconstituted, admitting her son as a partner.
how many partners were there?
Annexure D is there, my lord. More than two are there.
Family members, huh?
Like
Family members, others.
But up to that, the licenses are, my lord, to be renewed with effect from 1st July 2024. To
Yes.
enable that, I have applied for the grant of license by remitting the license fee first at page number 81 on 26/6/2024. This was also, madam, followed
You
by.
remitted the license when? When did you remit it?
That is the Chalan, my lord, dated 26/6/2024.
So before
This was expired.
before the
Yes. It was also followed by the application in the prescribed form, page number 50, Annexure L. If that's the signature, I have got the original copy also here. To demonstrate, Annexure L was made on 28/6/2024. Because the license fee will have to be paid advance. License fee cannot be paid unless it is countersigned by the authority. Goes to the online. Application is dated 28/6/2024, Annexure L, page number 50. On receipt of the application, the local officer, that is the inspector of excise, prepares the checklist. Annexure N may kindly be seen.
this annexure L is dated
It's dated 28, page number 55, minus the time.
28/6/2024.
On receipt of these, the inspector of excise, the local officer, but there is a system in government that it should go through several tables. Prepares the checklist, Annexure N.
Who prepares it?
Inspector of excise. Of the area. Bakari, that is the deputy superintendent of excise. Was Chakaru, Military Upavibhaga. Annexure N, my lord, it bears the state emblem on the top. I got the original.
Annexure M, huh?
N and M both. Yes. Raja Abakari Ilake, Abakari Nidikshakara Kachari, Madikeri Valaya. He prepares a checklist that there is no infirmity for the purpose of renewal of the license.
This is the inspector. Inspector.
And also countersigned by the Abakari Upavibhaga, both page number 62. Abakari Nidikshakara, Madikeri Valaya, Abakari Madikeri Upavibhaga. It should be for forwarding to the Deputy Commissioner of Excise. Surprisingly, Lord, I have collected some, after the earlier expedition, I have collected detailed
So
information.
annexure N had to be forwarded to the,
No, it is required to be forwarded.
had to be forwarded.
What he did is that, for his own reasons, the Inspector of Excise gives back the entire papers to the licensee. Other day, because Learned Council submitted, that application is not made at all. Here is a copy of the application, here is a copy of the checklist prepared in receipt of the application. Now, that is a history. Subsequently, I find the petition, my lord, that needs to order notice. After the notice was ordered, and when the matter is in progress before this honorable court, my lord, I received annexure Q, page number 68.
They considered your,
Reflecting that intimating the rejection of the dated 16/8/2024. Page number 68, my lord's order is previous. In which he says that, my lord, may kindly permit me to read. ಈ ಸಂಬಂಧ page number 769 may be permitted to be read. ಈ ಸಂಬಂಧ ಉಲ್ಲೇಖ 2ರ ಜ್ಞಾಪನ ಪತ್ರದಂತೆ ಅಬಕಾರಿ ನಿರೀಕ್ಷಕರು ಮಡಿಕೇರಿ ವಲಯ ಮಡಿಕೇರಿಯವರಿಗೆ ಸದರಿ ಪಾಲುದಾರರ ಪೈಕಿ ಒಬ್ಬರಾದ ಶ್ರೀಮತಿ ಮೀನಾಕ್ಷಿ ಶಿವಶಕ್ತಿ ಇವರು 6/1/2024 ಮುಕ್ತರಾಗಿರುವುದಾಗಿ ಸನ್ನದ್ಧದಾರರು ತಿಳಿಸಿರುವುದರಿಂದ ಮುಂದಿನ ಅಗತ್ಯ ಕ್ರಮಕ್ಕೆ ವರದಿ ಕಳುಹಿಸಲು ಸೂಚಿಸಲಾಗಿತ್ತು. ನಂತರ ಅಬಕಾರಿ ನಿರೀಕ್ಷಕರು ಮಡಿಕೇರಿ ವಲಯ ಮಡಿಕೇರಿ ತಮ್ಮದೇ ಪತ್ರ 3 ತಿಳುವಳಿಕೆ 27 ಹಾಗೂ ಈ ಕಚೇರಿಯಿಂದ ಕಾರಣ ಕೇಳಿ ನೋಟಿಸ್ 95 ಹಾಗೂ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಕೊಡಗು ಜಿಲ್ಲೆಯವರ ಕಚೇರಿ ಸಂಖ್ಯೆ 96 ಏಕೆ ರದ್ದುಪಡಿಸಲು ಯಾರದು ಎಂದರೆ ಸೂಕ್ತ ದಂಡ ವಿಧಿಸುವುದು ಎಂಬ ಮತ್ತೆ ನಿಮ್ಮ ವಿವರಣೆಯನ್ನು ಕೇಳಿ ನೋಟಿಸ್ 3 ದಿನದೊಳಗಾಗಿ ನೋಟ್ ದಿಸ್ ಆಲ್ಸೋ 3 days time was given in a show cause notice earlier. ಲಿಖಿತ ಸಮಜಾಯಿಷಿ ಸಲ್ಲಿಸಲು ಸೂಚಿಸಿರುತ್ತಾರೆ. ಮುಂದೆ this was replied and compounding penalty has been paid. Yes. Yes. Compounding penalty has been paid. It is not a compoundable because it is not an offence at all. Page number 81 is the penalty paid. To avoid the difficulty because the compounding comes when a case FIR is registered. Here he says that you have reported the death delay. So why it should not be cancelled is the deputy commissioner's that is compounding penalty has been paid, there is the matter. Now the next plan is ಮುಂದುವರೆದು ಉಲ್ಲೇಖ 7ರ ಮಾನ್ಯ ಜಿಲ್ಲಾಧಿಕಾರಿಗಳು ಮಡಿಕೇರಿ ಅವರ ಆದೇಶದಲ್ಲಿ ವಿಧಿಸಿದ ಅವಧಿಯ ಪಾಲಿಸದ ಕಾರಣ ಪುಷ್ಪರಾಜ್ ಅಸೋಸಿಯೇಟ್ಸ್ 6/1/2023 ಸಾರಿಗೆ ಈ ಕೋರ್ಟ್ ಪ್ರಕಾರ ಸರ್ವ ಸಮಾಜ ಕಾಂಗ್ರೆಸ್ ಅವರು 40,000 ರೂಪಾಯಿಗಳನ್ನು ದಂಡ ವಿಧಿಸಲು ಆದೇಶಿಸಿದ್ದಾರೆ. ನಿಮ್ಮ ಪುಸ್ತಕದಲ್ಲಿ ಪುಷ್ಪರಾಜ್ ಅಪರಾಧ
what is the basis for imposing of this penalty of 40,000?
What is chosen is section 45 compounding of any offence conducted can be compounded. That is capital punishment. But not in this case there is no offence at all.
What is the offence according to them?
According to them, that not reporting the death. They reported I have declared my loss.
That has been already reported. That has already. No, that is already been reported on 14/2/2024.
Compounding is also done.
Where is that any offence been committed by the petitioners?
This is section 32, that's not the offence at all.
No, how do you sustain this order? How do you sustain this order? Intimation, can you intimate legal head in favor of what is that photo? No, he is not. According to he is not sane. No, you have to justify. See, the offence would be if he has not reported the death of a particular partner of the partnership firm. He gives a memo, or rather he informs the deputy commissioner excise about the death of one of the partner, and that was taken note by you. And the inspector was supposed to forward this application of the petitioner. Instead of forwarding the application of the petitioner, he gives that application back to the petitioner herein. How is that sustainable? And the impugned order imposing of 40,000. What is the basis for you to impose? And how do you cancel the CL7 and 9? Allah, there are other. That such an endorsement can be issued before that consideration. Can be issued. No, now what should we do for the temporary?
Interim orders. They can cancel it thereafter if I am not entitled, because continuity is there.
No, that is one thing. That is one thing. That is one thing. You have not stated any reasons of what the petitioner's grandson or the grandson of so and so being the partner of the firm is an innocent person. You have not stated it anywhere. So you have to do an inquiry in a proper manner, not in this way. Not in this way.
Not individual.
Not in this way. No, what should we do now in this? We will rest. See, in the meanwhile, we don't implement that order of cash.
Going for interim.
What is that now? Now, what is that order now? By the impugned order? Now, what happens pursuant to the order passed at Annexure Q? What happens pursuant to the order at Annexure Q? Then correct. Now the Annexure Q now imposes a penalty on them. Annexure Q is the impugned order, Alba. What does Annexure Q? That is how they have referred to the penalty. Now, what happens pursuant to the order at Annexure Q? What happens pursuant to the order at Annexure? It is not renewed. Let him, Allah, we will. You place on record, why did you cancel the renewal and what is the basis for cancelling it?
Because of submission. The other based on the submission that they have written to the commissioner.
If we find there is some irregularity passed by the
Original document of the commission is not the. Why should it be done in the order?
Respondents, SCGP to accept notice for all the respondents, to file objections by 11th. 11th, no. In case they don't file their objections on 11th, they will consider in the preliminary hearing. The notes are correct.
Number 5, order.
Second list.
Then number 1.
Serial number 1. Why pass over? What is that urgency now in this matter, which you could not do before the trial court? There's an ex parte order. Right. Ex parte order, you can go before the trial court, file necessary. Then why do you come before this court? There are two things here. There is an ex parte order. You have filed your objections. You can also file an IA for vacating before the trial court. Wow, what is the hurry for you to come before this court? Can this court consider your application when the matter is pending before the trial court? Can it consider? Alva? What is that hurry for you to come to the court? Go to the trial court. Go to the trial court, make necessary application. Not at the station. Yes. What is that? Hmm. We are still in the second list, Mr. Consul. How do you come and make a submission? Please. Pass over.
This one, serial number 5, Chandrana.
Ah. This is a matter. Who is filing a memo for retirement? This matter was heard. Heard, Alva? This is heard. We will not accept your retirement. After the arguing the matter for some time, memo of retirement filed by the counsel for the respondent is not accepted, as this court has heard the counsel on both sides on 22/8/2024, and at the request of the learned counsel appearing for the respondent that they would endeavor to ascertain the possibility of settlement, the matter stood urgent. Full stop. List the matter for further hearing. We will not. Should not adopt such type of practice, Mr. Consul. After arguing, you file a memo for retirement. So please don't address the argument. She was here before the court at that day. We should not have given you time. Yes, next. Huh?
My lord, in serial number 6, I appeal.
Yes, Mr. Harish Kumar.
My lord, I'm sorry, my lord, the amount was not paid. And my lord, we preferred a writ appeal. My lord, I'll move that matter and I will see if it is not going to.
No, you have to pay the cost. First
Yes,
pay
yes.
the cost.
Yes, ma'am. I'll
When you pay the cost,
my lord, I pray for 3 weeks time.
petitioner is granted 2 weeks time to pay the cost imposed by this court
Please.
on data. Office objection now. It is listed for what, madam? For what is it listed? Is it listed for non-compliance of office objection? For what is it listed? Then, see, first thing when you come to the profession, you should know how you should look into the cost base. What is the stage? That's very necessary. So only then you will know how the system works. Yes. Petitioner at request of petitioner, a week's time is granted to do the needful.
8,
What is this? Petitioner counsel that the needful would be done during the course of the day. Office to verify and proceed.
next petitioner.
Petitioner to do the needful during the course of the day. ಇವತ್ತೇ ಮಾಡಿ. Furnish ಮಾಡಲಿಲ್ಲ first time. ಇವತ್ತೇ ಯಾವಾಗ ಆರ್ಡರ್ ಮಾಡಿದ್ದದು? ಏನಾರ ಜಸ್ಟಿಫಿಕೇಶನ್ ಬೇಕಲ್ಲ ಮಿಸ್ಟರ್ ಮೋಹನ್ ಕುಮಾರ್, ಮೋಹನ್ ಭಟ್ ಅವ್ರೆ, ಇವತ್ತೇ ಕೊಡಿ. Yes, Mr. Pradyumna.
We have furnished the year of the day, my lords.
Yes.
My lords, we have already furnished one address, which our instructions are the correct address, but we have also instructed the bank.
So you pay.
For an alternative address. That is there. We furnished to the office. Notice will be reissued.
Petitioner counsel submits that needful has been done. Office to verify and proceed. Yes, Mr. Swami.
I appear for proposed respondent number 3, my lord.
You will take notice for respondent number 3.
Yes, my lord. Yesterday I filed my wakalat.
What is your name, Mr. Counsel?
In Jagdish N, my lord.
Jagdish N. Counsel appearing through video conference submits that he has filed power for respondent number 3 in the registry. Office to put up the same. Yes. Now what? Next. Next
My
what?
lord, in this case, already the judgment to vacate the petitioner is already been awarded before the trial court where this counsel has appeared, and now it is at the stage of execution petition. And the petitioner is intentionally avoiding the delivery of handing over of the vacant possession of the scheduled premises. On this background, without even disclosing to this honorable court, has filed the present petition for electricity connection, which is an unfortunate that the petitioner is showing the attitude to this court. He has not at all disclosed, hope so. And now, and he has not even. Yes, ma'am. Yes, ma'am.
Huh?
Yes, my lord. I think
There is a disclose that you have there is an order of eviction against the petition. Yes.
Stated that he is also going to see.
No, there is an order. There is an order against you. Where is that?
Execution case is pending.
Where have you stated so? As on the date of the writ is, that on the petitioner have questioned with the restriction of civil court to entertain the suit. Yes. What happened to the execution petition?
delivery
Mr.
warrant. Delivery warrant is already been issued, my lord.
And report to the court. And after that, we will. At request of the respondent, counsel, appearing for respondent number 3, this matter after 2 weeks. Yes.
Much obliged, my lord.
You produce all the documents to that effect.
Yes, my lord. Much obliged.
Yes, Mr. Ajay Prabhu. Anything? This delay of 1,480 days. Yes, pass away. Yes. Now. So you're the pleading applicant? So notice was ordered on this template. So according to him, they are not necessary party. Objection to objections, There is the question of objection.
21 notification and let me verify. You have to pay and not
Objections are filed by respondent number 3 to I number 3 of 2022 for his pleading filed by the petitioner. Petitioner counsel seeks time to look into the objection. This matter on Wednesday. For what? In respect of whom?
Number 8.
8, Eight. Yes, we will allow that application. I1 of, yes, Mr. Counsel. Respondent number 8 is a necessary party in this petition. Respondent number 8. No, is this respondent number 8 is necessary? Yes, we will not say anything. We will hear this matter on merits on my Wednesday. Then we will decide whether it is necessary or not. You get ready for the group itself. Let it be in the very stage. There. When the APMC is there, who are you? Whom do you appear for? 9. Who is the contesting respondents here? So who are the contesting respondents? So APMC is the person who allowed. Yes, correct. So the APMC and the respondents herein are the proper parties and they are answerable parties. So if you are ready, we will take this matter on Wednesday. Wednesday. No, not 2 weeks. ಅಲ್ಲ, ಎಷ್ಟ್ ದಿವ್ಸ ಬೇಕು? You verify by a week. Wednesday. Yes.
Appear for the petitioner, my lords.
Six week of the statutory bodies. Because it's honorable courts have the interpretation. It's citations it is publishing.
Yesterday, senior counsel had already argued this. Yes, Rupashri, we are going to dismiss your petition. No
Please, my
interference.
lord. My lords, but that is on merits, my lord.
On, yes, on merits. The
Please,
interim,
ma'am. Interim order of 50%, my lord.
we find that it is not, it is correct. It is correct.
Please,
The
my
order
lords.
passed by me.
My lords,
Present-
that judgment was given, my lords, from the date of the domestic
Correct.
inquiry.
So, that we will answer. Domestic inquiry is not a criteria for avoiding the.
Please, ma'am.
The present petition by the management, Mrs. Toyota Kirloskar Auto Parts Private Limited, questioning the legality and correctness of the interim order dated interim relief dated 22/7/2021 in serial application 41 of 2014. 14, granting interim relief to the workman at 50% of his last drawn pay of rupees 29,041 from the date of dismissal. From the date of dismissal dated 30/12/2014 till the disposal of the case. The question that calls for consideration before this court is whether the granting of interim relief to the workman by the industrial tribunal is justified in the present facts and circumstances of the case. The workman was dismissed from service of the petitioner company on certain allegations of misconduct, industrial dispute was raised by the workman pending adjudication in AID 39 of 2014 before the additional industrial tribunal. The petitioner management filed an application under section 33 2B of the Industrial Dispute Act 1947, the ID Act for short, seeking approval of the dismissal of the respondent from his service, as he was one of the concerned workmen in the said dispute. The next paragraph, the tribunal on the fairness of domestic inquiry by order dated 29/9/2018 held that the domestic inquiry conducted by the company was not fair and proper. The workman filed an application under section 10(4) and section 11 of the ID Act for granting interim relief at the rate of 100% as per the last drawn wages from the date of dismissal till the date of dismissal of the case. Till the date of. The workman contended that he was dismissed from service on 30/11/2014, 30/12/2014, without any valid and proper reasons and with nullified agencies. That the inquiry officer has not followed the proper and has not followed the principles of natural justice while and he has not afforded any reasonable opportunity to the workman to contest the matter, and he was not permitted to cross-examine the management as to the management meetings. The that the charges leveled against the workman in connection with the alleged goes slow in his work is false, and it amounts to victimization. The workman contended that he has not been gainfully employed, and there is always a threat in the mind of the workman that he would be dismissed, and that there is a prima facie case established by the workman to grant an interim relief by way of interim protection of granting the wages during the pendency of the petition. The company filed a statement of objections to the application, inter alia contending that the allegation made against the company by the workman of not affording an opportunity and other contentions are false. It is contended that the company has followed the principles of natural justice and sufficient opportunities have been granted to the workman to prove his contentions before the inquiry officer. I sought for dismissal of the application. The tribunal, by the impugned order, in light of the power conferred under Section 10, subclause 4 of the ID Act to grant interim relief, and the exercising the power under the law, awarded 50% of the last drawn wages of rupees 29,014 as an interim relief from 30/12/2014 till the disposal of the case. The learned counsel appearing heard the SMUT learned counsel, senior counsel for the petitioner, and Ashok Harnari, learned senior counsel appearing for the respondent. Learned senior counsel appearing for the petitioner would contend that the order of the tribunal in awarding interim relief is without considering that the workman was dismissed from the petitioner company and the charges were of deliberate go slow inverted comma during the period 11 to 2014 to 18/3/2014, disturbing the normal operation and without considering the seriousness of the misconduct. The granting of interim relief pending dismissal of the serial application for was not justified. That the tribunal has erroneously come to the conclusion that the petitioner has failed to prove before the tribunal that the respondent workman has been gainfully employed and has a source of income. Taking to the cross-examination of the WW1, the senior counsel submits that the workman has clearly admitted in unequivocal terms in his cross-examination that he is having 2 acres of agricultural land. He is residing in his own house at Haveri, and that his wife is working as a nurse. He's working as a nurse and in spite of the categorical admission in his cross-examination about having a source of income and regarding the earnings of the respondent for his livelihood, the tribunal has erroneously, on an assumption that the farmers would not be getting regular income to lead their life, has held that the respondent is entitled for interim relief. Next paragraph. Emphasizing on the cross-examination of the workman, placing reliance on the decision of the apex court in the case of Northeast Road Transport Corporation and M versus M. Naganagoda, 2007, Part 10, ECC 765, submits that the workman was earning and gainfully employed and is earning and has a source of income from the agriculture pursuits to maintain himself, and the court below is not justified in holding that merely receiving an agriculture income the workman cannot be treated that he has been engaged in a gainful employment. And the gainful employment would also include self-employment wherefrom the income is generated. Learned Senior Counsel submits that the interim order bar relief granted by the tribunal is like awarding 17B wages, which cannot be decided until an award has been passed, and until an award is passed, non-consideration of the occupation of the workman that he had owned agriculture land and a house suffers, and the impugned order suffers from irregularity. For contra, the learned counsel, senior counsel appearing for the learned senior counsel Ashok Karnali, learned senior counsel appearing for the respondent, vehemently contends that the order of domestic inquiry being held to be fair and proper is not constrained before this court. The interim relief granted by the tribunal cannot be equated, is to be equated with the suspension order and treated, and the interim relief granted has to be treated as a subsistence allowance, as the workman needs to be maintained during the pendency of the proceedings. Full stop. That once the domestic inquiry is held fair and proper, the tribunal had jurisdiction to grant interim relief as paid and in the circumstances made out by the workman. Stop. The learned senior counsel submits that the workman does not cease until the tribunal grants permission to the company to the company under section 33 2B to dismiss the workman and to dismiss the workman from service, and the tribunal was justified in granting the interim relief at the rate of 50% part wages. Learned senior counsel submits that the object of 17B is considered and reinstatement is ordered. 17B is not applicable, and 17B is not applicable to the present time, as only 50% has been ordered by the tribunal. Reliance is placed in the case of reliance is placed on the decision of the apex court in the case of Fakir B. Reliance is placed on the following decision. Fakir B. Kulabai Solanki versus presiding officer and another AIR 1986 Supreme Court 1168. 1168. 1168. Then the senior counsel submits that pending approval before the tribunal under section 33 2B, the workman continues to be in employment during the period when the proceedings for approval of dismissal are pending consideration before the tribunal, and the pendency of the proceedings for approval does not put an end to the relationship of the master and servant between the management and the workman, and thus whether the non-existence of power to make an interim order does not to any extent render the power confirmed under section 33 2B read with section 35 ineffective or less effective is to be decided at that point, that the interim relief in an industrial adjudication is not pending or finding an issue of the validity or otherwise of the domestic inquiry. it is to be awarded notwithstanding the finding with the reference of the validity of domestic inquiry. And there is no necessity for the labor court to deter the consideration of the application for grant of interim relief till it enters its finding on the domestic inquiry. Next one. This court has carefully considered the rival contentions urged by the learned counsel for the parties and produced the material on record. So far as the power of the tribunal to grant interim relief is concerned, the law is no more a res integra, as the matter is covered by the apex court early in the year 1959 in the case of Hotel Imperial versus Hotel Workers Union 1959 Part 2 LLJ 544 and at para number 21, 22 and 23 it has held as under 1959 Supreme Court Part 3 92. It was urged by the learned counsel appearing for the petitioner that even if the tribunal had a power under section 10(4) of the Act to grant an interim relief of the nature granted in this case, it can be done so by submitting an award under section 15 of the 15 to the appropriate government and reference in connection made to section 16 and 16, 17 and 17A. The apex court in the case of Hotel Imperial stated Supra has held has conceded the contention as to whether the industrial tribunal has power to grant interim relief by way of directing payment of subsistence allowance to the workman in proceedings arising out of a complaint made by him under section 33A of the Act, complaining that he has been removed from service in violation of section 33 of the Act, which is deemed to be a reference or in a reference in which point of dispute is about the justification for removal from service of such workman. The apex court has laid down the ratio in 2 paragraphs as to the scope of power of the tribunal under subsection 4 of section 10 as under Roman 1, 2, 3. Roman 1, 2, 3 and 4. In light of the decision of the apex court in the case of Hotel Imperial stated Supra, the tribunal had power to grant interim relief under section 10 subclause 4 of the Act and the apex court of the Act. The apex court in the case of Fakira Bai Fakirabai Kulabai Solanki has held that the workman does not cease to be a workman until the tribunal grants permission under section 33 to dismiss the workman and the management dismisses the workman pursuant to such permission. An order of suspension by itself does not put an end to the employment. The workman continues the law stand. The workman continues to be an employee during the period of suspension, and it is for this reason, ordinarily, the various standing orders imposed in several factories and industrial establishments provide for payment of subsistence allowance, which is normally less than the usual salary and allowance that are paid to the workmen concerned. The apex court further observed that an order of suspension no doubt prevents the employee from rendering his service, but it does not put to an end to the relationship of the master and servant when the management between the management and the workman. Between the management and the workman. The apex court further observed that if no amount is paid during the pendency of such an application, it has to be held that the workman concerned has been denied a reasonable opportunity to defend himself in the proceedings, as the granting of amount by way of subsistence allowance is to maintain himself and the family members of his family, and also to meet the expenses of the litigation before the tribunal. Before the tribunal.
Relationship between the management and the
consequently vitiates the proceedings before the tribunal under subsection 3 of section 33 of the Act. Next one. Section 17B of the Act is in the context of the question whether workman is entitled to receive full back wages after reinstatement. In the case of Banur Lal versus Deputy Executive Engineer 2005 R1 LLJ 655. The division bench of the Gujarat High Court has held and considered the words inverted comma if the workman is not employed in any establishment and has found and held that the basic parameter for entitlement of the workman to claim back wages, full wages last drawn from his employer when the proceedings preferred by the employer are pending in High Court or Supreme Court are the words, and it is only when the court is satisfied that such workman has been employed in any establishment and has been receiving adequate remuneration during such period thereof, that wages for that period shall not be paid. The tribunal, considering the cross-examination of the workman and regarding the earning for his livelihood, the tribunal, considering all these aspects about the agriculture activities and the problems faced by the farmers, and explain the nature of crops grown and the availability, and in that circumstances, held that the admission of the cross-examination in his cross-examination would not be sufficient to hold that the workman is gainfully employed in order to deny the interim relief. Insofar as the contention of the learned senior counsel that the awarding of interim relief is to be from the date of domestic inquiry, is from the date the court held that the domestic inquiry is not fair and proper, needs to be considered. In that aspect, it is to be held that the order of domestic inquiry is not a criteria for the tribunal to consider whether the workman is entitled for interim relief, as in the present case, the application seeking permission under section 33 2B is a pending consideration. The tribunal, having conferred power under section 10(4) of the ID Act to grant interim relief, as awarded by 50% as the last drawn wages from the date of dismissal, which this court is of the considered view does not warrant any interference, and this court passed the following order. The petition is dismissed. The impugned order passed by the labor court stands confirmed.
My lords, one submission, my lords. With your Lord's permission, my Lord, I filed one judgment of this Honorable Court Division Bench, which says that the interim relief has to be paid from the date the filing of the application, my Lords. I produced it before this Honorable Court, my Lords.
Where is that? Which is that order?
I have it is PT Limited versus R Subramaniam.
When did you file it?
29/2021, my Lords. Page number 9, my Lords. 29/2020. Please, my Lord.
In that, was it an application under 33(2)(b)?
My Lords, it doesn't say that, but it is on grant of interim relief, my Lords. It says that interim relief has to be granted from the date the application for interim relief has been made and not from the date D is held not fair and proper.
Yes, which is that?
Page
Which order?
number 9, my Lords, in page number 9, TT Limited versus R Subramaniam and others. Justice Rama Joy's judgment, my Lords.
There's only one judgment which you placed reliance is writ petition.
My Lords got it, my Lord.
No, it's not available in the file.
My Lords, that the same file wherein Northeast Karnataka Road Transport Corporation case was filed, my Lords. It's in the last page, my Lords.
Yes.
That TT Limited, my Lords, page number 9. My Lords, in this case, in fact, in the last 5 lines, my Lords, in Mysore Siemens case, the court held that when an application for interim relief is made by the workman during the pendency of industrial dispute, Labour Court in the first instance should consider as to whether domestic enquiry is valid or invalid and therefore proceed to grant interim relief if domestic enquiry was invalid. According to the said decision, interim relief should be granted after recording a finding on domestic enquiry is invalid. It is nowhere stated that it could not be granted from the date of application.
It is not. It's nowhere stated it is to be granted from the date of application. Then
it could not be. It's written, my Lords.
Correct. So it has to be from the date of domestic enquiry having held to be fair and proper.
From the date of application, my Lords.
No. From after recording a finding that the domestic enquiry was invalid. It is nowhere stated that it could not be granted from the date of.
So that means it can be granted from the date of filing of the application, my Lords. 2 negatives are there, my Lords.
2 negatives. We have to say from the date of domestic enquiry. From the date of domestic.
Yes, my Lord.
From the date of domestic enquiry.
My Lord, from the date of the application of the interim relief being filed, my Lord, the last line, my Lords.
No, application, it is nowhere stated that it could not be granted from, it means the court says it can be also granted from the date of application.
Please,
either
my
from
Lord.
the application or from the date of the domestic, either of it.
Please,
it
my Lord.
Now, from when it has been granted now?
The order of the Labour Court is from the date of dismissal, my Lords.
It has to be from the date of domestic inquiry.
Date of application, my Lords.
Not date of application. Application is when?
Application was filed on 16/1/2015, my Lords, in this case.
2000?
16/1/2015.
And when was the domestic inquiry?
Domestic inquiry, my Lords, the order that was set aside, my Lords, it was it's written in the writ petition, my Lord. Just give me a minute, my Lord.
This is application.
29/9/2018.
2018,
my Lords.
So then from the date of application, it has to be granted,
Please, my lords.
not from the date of dismissal.
No, my lords.
Dismissal was when? 2014.
2014. Yes, my lords. Please, my lords.
The application was filed by the Workman on 16/1/2015.
15.
The tribunal has granted the interim relief from the date of dismissal. This court feels it appropriate that granting of interim relief has to be from the date of application, that is 16/1/2015.
Yes, ma'am.
And accordingly, this court passed the following order. Writ petition is allowed in part. The impugned order of the tribunal stands modified to the extent of holding that the respondent Workman is entitled for the interim relief from 16/1/2015.
Much obliged, my lords.
So 1 year he would not be getting that interim.
1 year only, my lords, but even then, that is the position of the law. I wanted to bring it to the notice of.
The judgment in the case of TT. Krishna's counsel for argument. TT Limited versus R. Subramanya and others. Yeah. In petition 693 at 2019.
Much obliged, my lords.
Yes. Yes, senior counsel, what happened? Huh? No, I don't know how this matter was not listed. It was directed to be listed.
I thought that.
I was at Kalburgi, we said it next week. Huh. I don't know how it was. And yes. Yes.
Seeing that you were staff, but then getting very a lot. I want to express that the actions which have been taken, which is impugned by the petitioners in this statement.
So you had.
That is what welcome I got.
Yes, because at that first.
I want to welcome a lot for that in terms of clause 45 of the
Correct.
all starts with the word that has been employed. And whenever all starts with relief, the procedure that is contemplated under clause 45 and 46 are followed. Hence, my lords felt that petition was justified when the prayer that they had sought. At that point of time, I submitted your order that the petitioners are not covered within the term staff that is allowed in the relief.
But you had employed them.
Very well, for just one. Because I made a submission that there are several documents indicated. Not only, my lord, from the time when I would step in as the lead holder of the respondent number 2, but also from the time when the respondent number 2 had employed this petition, which was, my lord, which documents, my lord, would date back to 2011. And I made the submission, my lord, saying that these are the documents which I intend process to run. Kindly grant me a date in the submission that
Yes, yes.
and the other option, my lord, are directed to matter of subsequent Friday.
Correct.
On which day, because in fact I had given my travel and also I I thought oversight. This is a line of.
Yes.
However, that has actually the entire day, which my lords not Indeed.
What is that IA?
Okay. Look, this is the IA, my lords, for production of additional document. But I must submit at the outset. The production, the filing of this IA is certainly not, I am certainly not employing a delayed time. That your lordship's time. And we go down, my lords, to the view that your lordship would take. But my most humble submission was permit me to file this IA today. I deserve, my lords, Because why this took time was, my lord, all these documents were, my lords, in the possession of the people, my lords, the administration, which managed respondent number 2, who are heading with the petition. We had to make a Herculean effort to secure all these documents to indicate that from 2011, they were seasonal workers, contract workers. Every year from 2011 until the date this lease deed was executed, their terms of the employment contract was renewed on yearly basis. Subsequent thereto, my lord, the invitation of which that was floated, my lord, by the state government would also indicate that these 21 workers are contractual workers. So their status as a contractual worker remained intact, not only from 2011 until the invitation of it, but also subsequent to the execution of the lease. So, my lord, my immediate answer to my lord's pointed question is whether we had employed them, we certainly did not employ them. They were given to us in terms of invitation of it. May I just take your lordship, just to point out as to why these documents which are intended to be in form of an IA become important. Have a look at the page of the petition, which is the invitation of it.
Yes.
The lordship, page number 140. Manpower at 2.15. But these workers who are there, my lords, at the institution of PSSK, which is my lords, respondent number 2 for the last. They categorized as permanent, seasonal, and contract.
Yes.
Contractual workers number 21 are the petitioners before the last.
Yes.
Because these contractual workers who number 21 who are the petitioners before your lordship were appointed in terms of one sample letter which the petitioners themselves would produce, which my lord would get at page number 108. Have a look at page
108.
108.
Yes.
108, my lord. Third line. ಕಾರ್ಖಾನೆ ಕೆಲಸ ಕಾರ್ಯಗಳನ್ನು ಸಲುವಾಗಿ ನಿರ್ವಹಿಸಲು ಗುತ್ತಿಗೆ ಆಧಾರದ ಮೇಲೆ they have been employed as contractual workers. The petitioner by law would conveniently produce only this communication of 2011. What I have with me, my lord, which I intend to produce in the form of IA, is from 2011 until the point of execution of the lease deed. Their terms of employment have been.
Once you had taken over the factory, you had employed them. Is it not?
No, I am my submission to your.
As per the clause 46, as per clause 46, there was a clause which indicated.
Page number 169 and 170.
I got it.
46.
I got it.
Is it?
Well, there a word that has been used in clause number 45, 46, fellows, I have.
Yes. So according to
So,
you.
I get to ask, could staff include these contractual workers whose status has never been permanent in.
What we asked you on the last occasion is whether an endeavor could be made on your part to employ these workers. Is it not? That was.
Well, I'll make this submission. I am an employer. I am another as a private individual, not as PSSK. Point number 4. Because I am employed more than 1.5 lakh individuals across this country. So, Lord's law of prudence would certainly dictate me that if I am employed more than 1.5 lakh, why should I have a grievance with these 21 individuals?
So you could.
I have certainly no grievance with this individual, provided.
Yes. Look at the circumstances how this things went. There was a clause inserted. You took them into service. You took them into employment. You took into employment. After that, suddenly they realized that you're not going to take them into employment. Right.
My stand was not that I not taken them.
But you refused to take them.
No, I did not refuse to take them also.
What
I did, my lord, was these 21 employees were handed over to me by PSSK.
Correct.
That communication, your lordship should get. Was that I can just point out, my lord, that communication. At the page number.
So this is the,
But they handing over of these employees by PSSK to MRN who are the leaseholder.
this was when 2020.
At the time of execution.
20.
What are the different baskets of employees from PSSK who come to distribution of leaseholder? That is the problem. So the basket of employees were defined in the invitation to bid. Okay, I paid the
Now, pursuant to this order, that is 10/7/2020, for how many days did you employ
One
them?
year. Thereafter, I would say that in 2011 in the year of the contract, one sign variant. That is the offshoot of all this. They would contend, but can you imagine the situation, my lord? From 2017 to 2020, from the time until a point of time when I would enter into this state of enterprise, these employees were not even paid salary. I would infuse crores and crores of rupees. Say that look, I want to revive the state government enterprise. I would take it on a 40-year lease. I am willing to employ you all, provided the conditions of service that existed from 2011 until now shall be continued. That is when they say that you are a private player, you have all the money, you cannot treat us like a temporary employee like how we were treated.
They are not asking for regularization, but don't remove me in such a manner. That is their grievance.
No, my God, there are
Regularization, you can always go, they can always go before the labor court.
But that is their
So that prayer is something else, but now they cannot be denied employment. They are contract workers directly employed with the company, right? Directly. Directly. See, there are two types of laborers, right? There's one is direct employment, that is contract basis, and one through the outsourcing by a contractor.
Contract employees who are engaged by, but I would rather say that just to avoid confusion, just to clear myself in but they were employed on a yearly basis, on a contractual period which is renewed year after year.
Since when?
Since 2011. And these are the documents which are to indicate that they are contractual workers who are employed on a yearly basis. Now, what I would do, my lords?
If that is permissible in your establishment to take them for some period,
Only for one particular year.
do it.
No, they have taken them. But their difference is, my lord, that they are not going to continue to sign the yearly contract which they have been doing since 2011. That is how, my lord, they would come before your lordship. But once they refuse that they are not going to sign this yearly contract, what I would do is I would issue communication, my lords, to the respondent of PSSK, saying that they are no refusing to comply with the terms that we are, my lords, indicating, which, my lords, is in accordance with Lease. But let me not be mistaken that I have done something apart from the Lease. It is not their case that I have not paid salary. It is not their case that I have treated them or I am giving them work which they are not intended, which they are not employed to do. Their case is that we should be treated on par with regular employees, for which, my lord, they maintained stoic silence in 2011 till 2020. Now, my lord, what I would do, just to answer my lord's question as to what I did, my lord, I would address the communication to PSSK, about which communication your lordship will find at 210. Can you have a look at page number 210?
Yes.
I would say that these employees should be sent back to PSA. This communication which I had issued has not been challenged with petition. I shall stand corrected in the event my conductor appearing. This communication which I have issued, handing them over back to PSSK, has not been challenged even to this. Your lordship may record this submission. So, my lord, this is the answer to my lord's pointed question as to what I did. I engaged their services from 2020 to 2021. 2021, when I call upon them to say,
Services engaged for?
2020, there was the date of execution of these.
That is 10/10/2021. 10/10/2020. 20, right?
From 20 to 21.
To 21.
But thereafter, my lord, I will address this communication on 29th of March 2022. This communication has remained unchallenged even to this day. So, The answer to my lord's question as to whether there has been the conduct of the respondent number 4, is it breach of clause 45? Answer no, because my conduct is my lord explained in this communication of 29th of March 2021, which my lord petitioners in my most respectful submission has welcomed with open arms.
Yes.
Now, subsequent to that, my lords, the respondent number 2 would say that I don't intend to embark your services anymore. For relief. That is what is challenged before. So, if at all they have a grievance, my most respectful submission, I am certainly not here to contend that they may have a grievance. Certainly, yes. But that grievance could not be agitated against respondent number 4 and most certainly not in a writ. They have got to take up the matter before the jurisdictional courts against PSSK. And in the event, my lord, their cases, which I am certainly sure is not that case. But I am not paid their salary, their conditions of work. After me stepping into the shoes of respondent number 2 is inappropriate or violative of his leave.
They are agreed to the extent of hopes given by the respondent number 4 from 20 till 21.
Today,
One nimsha.
but today, my lord,
21.
if those hopes have not been met, I am making this. That have certainly been given in employing them.
But you would only on basis of this.
Contractual language which has been there since 2011. Well, 2011, well, I am making the submission repeated caption. Well, pardon me. Lakhs and lakhs of employees, well, and I am running a stick in the state government interference with taxpayers' money nothing in this state. Well, kindly by the situation. And then this leave. What is the grievance that the petitioners would have? For 3 years they were not paid. They continue to be not paid.
Yes.
Now in 2020, when I am coming there, that look, for 3 years you are not paid. I will resign. I am going to infuse courts of proceedings. I am going to give you salary. Their ask is, you don't want to be temporary, we want to become permanent. So, let's to assist your lordship, well, it's because there was a funded question from God. To demonstrate as to why there is no foul of clause 45 or not.
Yes.
Because my assistance at the preliminary stages, by inviting your lordship.
Yes.
These documents, my lord, which I have been able to secure from the accountant and the administrator of case, accurate effort, because my lord, obviously they were not doing it to me. Because I have been able to accumulate as many documents as possible. Indicated that they have voluntarily signed these documents will be these petitions are voluntarily given an undertaking that we have on contractual basis. These are documents, my lord, which have been signed by the petition.
Yes.
And I shall take your lordship to all of these documents. So, my lords, it is not a case simplistic, my lords, that one fine day I wake up and say that 21 workers don't want. I don't want to employ you. My lords, permit me to make this submission as well to justify my conduct. My lord, this is I run a sugar industry, crushing industry. As my lords are aware, this is not a activity which could be conducted throughout the year. But it is only when the crops are ripe for cutting the one thereafter I have to engage upon service for laborers. It was kindly my situation as to why there were contractual workers, why there are permanent workers. But these permanent workers who are there, that's because I took instruction from the respondent number 4 only to assist a lot, justify my conduct. But these are permanent workers who are engaged in the overall repair and maintenance of the machinery which run in the plant. The contractual and temporary workers are engaged as and when the activities commence in the sugar plant. Because after the sugarcane melon season concludes, I am assuming by October, September or October,
Yes.
there is absolutely no activity in this factory at all, except for the repair and maintenance that takes place of the machine. So, as an institution, notwithstanding the case of the merits of the matter, as an institution, as a factory, which is a practice throughout the country, not only in this particular country. Throughout the country, this has been the practice. So, these contractual workers are told that we may not need your services now. You come back again once the season. So, my lord, this is the nature, my lord, of the services that are intended upon the petitioner. Now they ask of the petitioner, why I say, my lord, why I am submitting the conduct of the petition. Qualified. But my limited understanding of the law is that whenever a subject matter is seized of for adjudication before your lordship, the principles of contempt of court, my lord, you contemplate. In fact, my lord, I had an occasion where your lordship was deciding on the judgment. The first time, my lord, the conviction was against the council, and his judgment was upheld by the Supreme Court. This call would say that an advocate is guilty of committing contempt for filing repeated writ petitions, and he cannot take the defense of his client instantly. Your lordship, my lord, I had a but the principles of contempt of court that even having a discussion on the merits of the matter would cause all of the administration. That, my lord, in my most respectful and limited understanding, the principle of contempt. Well, interestingly, my lord, why I am inviting you, my lord, this slash, just to indicate the conduct of how the conduct of the petitioner is. My lord, they would address communications to the Honorable Chief Minister. They would address communications to the Honorable President of India, saying that there has been injustice that is caused upon them and kindly subject euthanasia. I am sure, my lord, with the aggression that they are pursuing this matter before your lordships, submitting themselves to euthanasia is far-fetched. But I am certainly not on that. But their conduct, my lord, is communicating one after the other. When the matter is why they grant us an interim order. Which interim order we have followed, we have shown utmost compliance even to this day. I stand corrected in the event my learned friend would say that we have not complained, we have not paid salary. Despite no one discharged by the petitioner even to this day, even to the date of grant of the order this day, but there has not been a single brick that has been removed from point X to point Y by all these 21 petitioners for the last more than 3.5 years. But I continue to pay them salary. Why I continue to pay them salary? Because I am before your lordships, I bowed out to the orders of the
Now, this case is one peculiar from the other case. That's the reason this court asked you on the other day. Now, as far as regularization is concerned, he has to go before the labor court illustrator. Now that he is seeking for other prayers now in this petition, other than the orders, that is annexure yes, which has been passed. That is on 33/2021. What is that order? Annexure yes.
33, my lord, is the order that was passed by respondent number 2, leaving their service. So, who is my lessee? My answer.
Pursuant to your transfer, that is your intimation, which your intimation on 29/3/2021 to the respondent number 2, they have passed this order. So respondent number, who appears for respondent number 2 here?
That is more surprising.
Just respondent number 2 is the one who was the original employer of the your lesser, subsequently as witness. Now that at all you want the second respondent or such notice being issued by the second respondent.
I just would like to make.
Yes. You file those I.
Actually, file it to make them.
Yes.
Two things, because since he's filing an application.
Copy is served to him today or?
First and foremost, I have not made any prayer against fourth respondent at all.
Yes.
All along, I have been the employee and worker of the second respondent. Admitted fact is that I have been continuously working, whether there is an artificial break in service.
The second respondent is not functioning right now. Is it functioning?
We are putting given on lease, only the fact that provides.
It's not, it's already been leased to respondent.
Also, respondent 4. Yes, respondent. Please no.
Yes, what is it?
Yes. Because we have got any claims for the period which is paid again in the script petition. For the recovery of the outstanding amount prior to the execution date.
Only to that extent.
Ultimately, I am paying as a lien holder. Question number 2, very well can disclose those amounts to the petition, simple as they find that the claims contain some amounts of credibility.
Yes.
So if the official of the petition is going to be that there is no relief against me, because my separate permission to the last, because really interim order that expires, continue to engage the services or not. Ultimately, my lord, this grievances against respondent number 2.
Yes. Yes. Only to the extent of what there is. Now that you have not challenged the order dated 29/3/2021. Yes. You are challenging the action of respondent.
That I have never taken the contention at all. Then look to the pleadings. Page number.
Contentions is different. Contentions is different, and what you have challenged in this writ petition is something different. Yeah.
I haven't evaluated that is
What authority you could have to seek for regularization against the respondent?
my first prayer.
Yes.
Why exactly I brought the prayer? I just would have known. Yes, the brief history of it.
We know the facts, Mr. Muralidhar Peshwa. We are already know the facts. So just tell us what you want to submit.
Can you repeat to the page number?
Yes.
10/7/2020, annexure K. Page number 170.
What is annexure A?
Annexure K, page number 178.
Yes, that is the order.
That's a memo which has transferred the existing workman
Of PSK.
of the TSSK
To
the fourth trust.
Yes, correct.
The list sometimes even meets the 21 worker hours.
They are not disputing that.
Yes, why I'm coming to the process. So from 11/7/2020, I will continue to work as per memo dated 10/7/2020.
In the same capacity as you were working in the PSSK. Alva same terms. Same terms.
Nature of work here.
Same terms.
Same nature of work, whatever I was performing. Continue what? I don't know.
Yes.
So all this, in fact, there was no discrimination made as it is in this memo dated 10/7/2020. That he is a seasonal workman, he is a permanent workman, is a permanent workman. No such discrimination at all is made in the sector. This memo dated 10/7/2020. Everybody who are working as it is prior to 10/7/2020 were transferred as it is.
In the same terms. In the same terms. That is very important.
Right? Same nature of work.
Let us understand the facts, Santa. So same terms.
They have been working since 2011. That's a fact.
2011 as contract laborers from 2011, which was continued with respondent number 4.
Yes.
So not in dispute. Those facts are not in dispute.
Yes, exactly. What? Other one would be Chapan. They have a separate certificate standing order.
Standing order.
Their own certificate standing order doesn't even discuss anything about. There's no definition at all. I produce certificate standing orders as an action.
Yes, yes.
There are only two classes of workers. Majorly, just taking that. Election game.
Connection A, Workman, permanent workman, page number, connection A, page 46. Eligible copy, na?
Yes, yes. 46. Workman, permanent workman, body.
Workman, permanent workman, workman and including an apprentice, employed in the Karnataka to do any skilled, unskilled, manual, character.
ಅದೆಲ್ಲ ಆಯ್ತು ಬದ್ಲಿ ಆಯ್ತು ಪ್ರೊಬೇಷನ್
Permanent workman
ಆಯ್ತು
ಆಯ್ತು.
ಸೀಸನಲ್ ವರ್ಕ್
Seasonal work type, probationary, seasonal, casual work, temporary work. Is a worker who is appointed in writing for a period of work which is of essentially a temporary in nature. To be finished within a limited period. That is. So definitely you are temporary worker one thing. ಇಂಥ ಅವಧಿಗೆ ಮಾತ್ರ ನೀವು ಇಂಥ ಕೆಲಸಕ್ಕೆ ಮಾತ್ರ ತಗೊಳ್ಬೇಕು ಅಂತ ಹೇಳಿ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. ಆ ತರ 2011ರಿಂದ 2020ವರೆಗೂ
11 that is not for them.
So I'm not saying only for the purpose of
Unknown doesn't come for them.
I'm not telling you. I'm just only telling that. So there is no provision as it is.
In respect of Pandavpura
Sakare
Sahakara.
Karthane, only respect to respondent to I'm making this.
So respondent number 2 is fine.
Yes.
You are not now, they have already.
I'm trying to bring this. What is the nature of work I was performed? How exactly I was there in Sakwaran since 2011, directly used to disorder. Only for that purpose I'm bringing to the local service. So fact remains as per annexion A is concerned. All this underlying work, including me, were transferred as per their own reason. To make fourth trust.
Yes, yes.
Definition of staff. Definition of staff is a general term. Whoever is employed in the industry, in an establishment, they are all staff.
Yes.
As per Industrial Dispute Act is concerned, you can have the definition with the worker as or with the supervisor. But the general term of a staff is all those people who are employed
Yes.
in an organization, they're all staff.
Yes.
So as per clause 45 and clause 46, a definite provision is also mentioned.
Page number?
169 of the liquidation. That is an unregistered. That's the reason. That is being once again brought into the legality. The lease deed in 2023 elections. But it's still registered. The leaseholder shall carry on its activities under this lease with the existing staff of the factory to the extent possible. The staff presently working in factory shall work under the control, supervision, and supervision. So the leaseholder would be at liberty to appropriate responsibility of the staff at liberty to bring any officers and staff on their own unit to facilitate the full working of the lease. Also, the leaseholder is at liberty to recruit required staff. No liability whatsoever is not shall be fastened to the factory by the leaseholder. All such recruitments restricted to the period of lease. All liabilities thereof shall be upon the lease. The leaseholder shall continue the service of all the staff of it as far as possible. In case of not possible, what is this remedy? Various could be moved for reducing the existing staff in consultation with the employees and with the approval of the Commission of State Development and Director of Sugar, Government of Karnataka. The expenditure of implementation of VRS shall be discussed with the factory. This is one important condition which is. What exactly happened to us? The fourth respondent wanted to terminate me, which is absolutely impermissible. He could not terminate it because he was not appointed. He was not. I could not have been terminated by the fourth respondent. So I make a representation here to the Assistant Labor Commission, contending before that, I also make a representation as for annexure B to the second respondent. I don't get any representation. I don't get any response from the managing director of the secondary school. Hence, I make sorry for the interruption. Complete.
No, sorry. Because there is no material to indicate that I intended to terminate. Terminate is different from delete it. That was my entire
Yes,
case. Because let not may not the facts be distorted to the extent that I intended to terminate. The term of the contract was over. I intended to delete. Let the limit say that I intended to delete.
Yes, they issued a letter to the PSSK. They are relieving so and so work.
They want to terminate it.
Relieving. Terminate. Facts ಅನ್ನು ನಾವು ಚೇಂಜ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ.
ನಾನು ಹೇಳೋದು ಚೆನ್ನಾಗಿ ಹೇಳ್ತೇನೆ. ಏನ್ ಮಾಡಿದ್ರೆ ಅಂತ ಹೇಳಿ.
Yes.
I make one more presentation on 7/4/2021 again to ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರು PSSK. ಇತರ ಬಾಕಿಗಳನ್ನು ಕೊಡಿಸುವ ಬಗ್ಗೆ ನೋಟ್ ಮಾಡ್ತಾರೆ. ಅವರಿಗೆ ನಾನು ಪತ್ರ ಬರೆದೆ. ತದನಂತರ I also make a representation to the deputy commissioner, ವಿಶೇಷಾಧಿಕಾರಿಗಳವರು PSSK. He happens to be the special officer for PSSK about my pending orders. Then your options. Then you can to my representation given to the Assistant Labor Commission.
Yes.
PSS ಕಾರ್ಖಾನೆಯ ಕಾರ್ಮಿಕರು ಕಾನೂನು ಬಾಹಿರವಾಗಿ ಕಾರ್ಮಿಕರು ವಜಾ ಮಾಡುವ ಆತಂಕ. ಈ ಮೂಲಕ ತಮಗೆ ತಿಳಿಸಲು ಬಯಸುವುದೇನೆಂದರೆ, ಈ ಕೆಳಕಂಡ ಕಾರ್ಮಿಕರು ಪಾಂಡವಪುರ ಸಹಕಾರ ಸಕ್ಕರೆ ಕಾರ್ಖಾನೆ ಸುಮಾರು 11 ವರ್ಷಗಳಿಂದ ಕೆಲಸ ನಿರ್ವಹಿಸಿ ಸುಮಾರು 6 ತಿಂಗಳ ಹಿಂದೆ ರಾಜ್ಯ ಸರ್ಕಾರವು ಈ ಕಾರ್ಖಾನೆಯಿಂದ ಚಾಲನೆಯನ್ನು ಖಾಸಗಿ ಸಂಸ್ಥೆಗಳು ಬಿಡುವುದು. ಆದರೆ ಕೆಳಕಂಡ ಕಾರ್ಮಿಕರು ಇಂಧನ ವೇತನ ಹಾಗೂ ಇತರ ಯಾವುದೇ ಬಾಕಿಗಳನ್ನು ಪಾವತಿ ಮಾಡಿರುವುದು. ಈ ಬಗ್ಗೆ ಆಡಳಿತ ವರ್ಗದವರ ಕೋರಲಾಗಿ ಆಡಳಿತ ವರ್ಗದವರು ಕೆಳಕಂಡ ಕಾರ್ಮಿಕರುಗಳನ್ನು ಕೆಲಸದ ತೆಗೆದು ಹಾಕುವ ಪ್ರಯತ್ನ ಮಾಡುತ್ತಾರೆ. ಕೆಲಸದಿಂದ ತೆಗೆದು ಹಾಕುವುದನ್ನು ಆಂತರಿಕ ಆಡಳಿತ ವರ್ಗದವರು ಈ ರೀತಿ ಕಾನೂನು ಬಾಹಿರವಾದ ಕ್ರಮಗಳನ್ನು ಕೈಗೊಳ್ಳುತ್ತಾರೆ. ನನಗೆ ಮತ್ತು ನನ್ನ ನಂಬಿರುವ ಕುಟುಂಬದವರಿಗೆ ತೀವ್ರ ಅನ್ಯಾಯ ಮತ್ತು ತೊಂದರೆ ಉಂಟಾಗುತ್ತದೆ. ನಾವು ಮತ್ತು ನನ್ನ ನಂಬಿರುವ ಇದು ಬರಬೇಕಾಗುತ್ತದೆ. ಆದ್ದರಿಂದ ನಾವು ಕೂಡಲೇ ನಿರ್ಧಾರವಾಗಿ ಆಡಳಿತ ವರ್ಗದವರಿಗೆ ನೋಟಿಸುವೊಂದಿಗೆ ನಮ್ಮನ್ನು ಕೆಲಸದಿಂದ ತೆಗೆದು ಹಾಕುವ ಪ್ರಯತ್ನವನ್ನು ನಿಲ್ಲಿಸಬೇಕು ಎಂದು ನಾವು ಮೊತ್ತ ಕೋರಿಸುವುದು. I made my point very clear. ತೆಗೆದು ಹಾಕುವಂತದ್ದು after this representation, there was a notice by the Assistant Labor Commissioner. The original copy, paper copy was there in 2 offices. ವೇತನ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಆಡಳಿತ ವರ್ಗದವರು PSS ಆಗ್ತಿ ನೇರಾಣಿ ಶುಗರ್ ಪಾಂಡವಪುರ ರೈಲ್ವೆ ಇವರು ಕಾನೂನು ಬಾಹಿರ ಕಾರ್ಮಿಕರನ್ನು 21 ಕಾರ್ಮಿಕರು ಸಲ್ಲಿಸಿರುವ ಅರ್ಜಿಯನ್ನು ಈ ಪತ್ರದೊಂದಿಗೆ ಲಗತ್ತಿಸಿದೆ. ಸದರಿ ವಿಷಯದ ಬಗ್ಗೆ ಜಂಟಿ ಸಭೆಯನ್ನು 24 ಅಪರಾಹ್ನ 4:30 ಸದರಿ ಜಂಟಿ ಸಭೆಗೆ ತಪ್ಪದೇ ಹಾಜರಾಗಲು ಈ ಮೂಲಕ ಸೂಚಿಸಿದೆ. ಈ ಮಧ್ಯದಲ್ಲಿ ಆಡಳಿತ ವರ್ಗದವರು ಯಾವುದೇ ಕಾರ್ಮಿಕ ತೆಗೆದು ಹಾಕುವ subsequent to this, before the spawn happens,
Yeah, conciliation.
Your prayer against fourth respondent is seeking for regularization. Para number, your prayer at B of the
It's
writ
not for
petition.
fourth respondent.
See, it is for the fourth respondent. To reinstate all the petitioners versus, then what does it mean?
Look at that.
Prayer D.
Clear deal. Any funders or any other authority direction for that to be issued directly the second respondent.
Give appropriate direction.
Yes, we give upper direction fourth respondent. That is.
In other ways, you are seeking for a direction from
Absolutely.
the
In
fourth
fact,
respondent.
I want because I have been an employee of the second. It is second respondent who has caused the termination of my service. If it is against the very hard and for purpose for which the entire lease was given to them, including various board meetings, including as the lease agreement for that. The second respondent should direct this because what has happened was they have issued a vague direction, the fourth respondent. Come to that point.
That is not in challenge before this.
That is not as challenging. The four vague response have given it.
Is that order which you have challenged?
That is connection, yes. The termination.
That is the order passed by the second respondent.
Absolutely right. It's correct. Now, I have made all my efforts here. Because ultimately, I have been absolutely prejudice and unfair treatment have been passed against me. And there was continuous representation by me to the concerned authorities.
When you were with the second respondent, did you make any application or did you seek for regularization before the second respondent?
Regularization never arose at that time because I was continuously performing. I never have the thought also that I will be faced with this situation. Let me be very frank enough. Let me be very frank here. From the last 2011, when I have been continuously serving this organization, never even had a thought that I will put into the streets in this such of manner just because both respondents wanted to do that. Second respondent, second is humanity disease. Yes. All things that comes to the picture only because of this substitution. Otherwise, I was making a representation to ensure that I am not. Can you look into one more?
Mr. Peshwa, only to the limited extent.
Because
we have heard this matter. No, that is already heard. We have heard this matter. It's only in respect of the submissions now made by the, in addition. Ashtalla, it has been again. Because the court does not say anything doesn't mean you should go on continuing reading. So you just have to say, no, I'll not drag on. You have only to limit to the extent of their contentions. We understood. You said you were as a contract workers with the respondent number 2, and in light of clause number 46, they have been 45, 46. The respondent number 4 having taken you in service or employment. Now the employment could not be suddenly stopped, and you.
Please transfer back to second respondent. There was no mandate at all for the.
That is an illegal action on part of the respondent number 4.
Oh, that is not an illegal part of
What is that?
When I was submitting, what my letter friend is submitting, but my action.
Which is not being challenged, which is not. That is not challenged. Which is not challenged, but your action is against your grievance is against the respondent number 2 who has issued notice to you saying that you henceforth not been required in light of relief. That's all now. If at all you want to file this documents, you look into the documents and then.
So what they were doing from 2011 until this day?
Yes.
Have you even asked for regularization? He answered, I was referred to from the revision of documents. Oh, because every year they would give an undertaking that they have been employment contractual. Now, because I invited my lord attention 15 minutes with all the communication. Where my lord please employ. Petitioner, my lord, and they get fired.
Page
Look at
number.
my lord, page number 140. Just 1 minute. But take 1 minute. But these petitioner, my lord,
One first thing. See, we want to be facts to be correct. It's not that facts we should not go wrong.
ನಾನು ಫ್ಯಾಕ್ಟ್ ಎಲ್ಲಿ ಯಾವ ಪುಸ್ತಕದಲ್ಲಿ ಮಾಡಿದ್ದೇ ಇಲ್ಲ. ಯಾಕೆ ಹೇಳಿದ್ರೆ ನನಗೆ ಕೊಟ್ಟಿರುವಂತ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಆರ್ಡರ್ ಸಹಿತ ನಾನು ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದೀನಿ. ನನಗೆ ಕೊಟ್ಟಿರುವಂತ ಎಲ್ಲ ಆದೇಶಗಳು ಸಬ್ಮಿಟ್
We
ಮಾಡಿದ್ದೀನಿ.
would have submitted everything, but this court needs to look into everything, right?
That's what I was making submission.
ಯಾವ್ದಂತ?
This court has given opportunity. If there is that, please, I mean,
What is that? Which is that? Yes, yes. Yes, which is that you want to place? Manpower.
These petitioners before your lordships have been shown as contractual workers who are 21 in number. Plus, I ask myself this question: have the petitioner, in the event they are agreed, or if their case is that they are permanent or they come within the umbrella of the definition of staff, they could have very well challenged this petition of fact, showing them as contractual numbering 21. But there are in total 121, 120 employees, my lord, who are paid. Transferred from PSSK to MR, who was the respondent number 4 before your lordship.
Yes.
So the exception of these 121 workers, none of the employees have any claims against me. And my case before your lordship said, not that I did not embark their service, but what is the nature in which I embarked their service? The nature in which I embarked their services when they were handed over to me upon the execution of leave by respondent number 2 was in the same nature as they were employed under respondent. And my lord, my learned friend, read your lordship's clause number 45. I am given, my lords, the right and liberty to engage the services of the members of the PSSK, who is respondent number 2, to the extent possible. Insofar as, my lords, the other employment benefits, my lords, that are set out in clause number 40,
Yes.
there was absolutely no objective. So, classification of these employees in different baskets of permanent contractors.
Yes,
So,
understood.
I should raise it, my lords,
Yes, let him file. Yes, what is that you want to say? Really? It is the answer to your question, Nita. The answer to your submissions, rather. Really.
What was typing?
Hmm.
See, the whole action here, only by challenging or even including the challenge of the transfer of employment to the PSS will not definitely suffice its purpose. Ultimately, what is the result which has happened? I haven't put it out of the
You
employment.
look into those documents.
I haven't put it out of the employment. And it's also what is admitted fact that the fact itself is having some turbulent period. The turbulent period, I have not even sought for my wages since 2007 to 2018. Not only to me, but all 109%. They were not well paid. In fact, you are getting assurance that the fact will get revived. They will also be given some property wages. The fact remains that the other remaining 80 and odd workers, they have been paid all the pending wages since 2017 to 2000.
That claim is against the respondent number 2.
That is what prayer I want to believe. That's a prayer. I have not even claimed a single prayer from fourth response.
There is no,
There is no pending wage as it is on fourth
Yes,
response.
that's right.
They should not.
only if there is pending you would seek.
Absolutely.
There is no pendency or there is no
That's
pending.
I have made a case. I have brought the facts because not trying to preach or like making technical subject of prayer for the cut or preach. Otherwise, I will have to speak like whenever I am speaking, what is the purpose?
Yes. Now that you have already submitted, what is your prayer? Your prayer is in respect of respondent number 2 and respondent number 4, you are seeking for regularization or rather a direction from PSSK to a direction to respondent number 4.
That's like how they have continued to service.
This is another way of seeking a regularization in this matter. Alva.
Because ultimately, tomorrow they will also take contention. I have not appointed you, I cannot regularize this. Because I am not an employee, I am a lease holder. Because PSS, that is both a small.
You have already given a synopsis, Allah, Mr. Muralidhar Peshwa. You have given a synopsis, yes? You have given a synopsis, So please synopsis along with this documents. So we will conclude here. To file an application. Who is the instructing counsel? Your senior counsel, right? Ajay Katkar, Learned Counsel, has filed. You are filing it in the registry. Submits that the respondent number 4 is filing additional documents in support of their contentions for objection, statement of objections filed in the present petition. The respondent number 4 is permitted to file the additional documents by serving the copy of the additional documents on the learned counsel appearing for the petition. And the petitioner is at liberty to file objections if any. No objections. Then
I have some additional documents. Very important, very precious. That also permitted to.
when will you file
I need only 2 days of time.
this matter on Tuesday? Tuesday. 11th, we usually take the other matters. Tuesday at 2:30.
But like, I was completely on a lighter note. Like, by the petitioner have certainly not given any concession.
So we're not claiming any.
By not claiming what is not there, but in fact, I have shown you the concession. By methods, since there was a direct entry model that was passed by Honorable Court, even to this day, I am continuing to pay their wages without their performing methods, even a single word, even to this day, as I make this.
So you place the synopsis also
Right, yes.
by Tuesday. Respond. This matter at 2:30 on Tuesday for further hearing.
Order, then number 60.
It had to come for further hearing or dictation. What was it? You are claiming as per the select list of 1992 notification. Now you are taking the probation at a belated time, grievance. The
fact that the government order is in my favor and that government order has been implemented.
No, you have not questioned the probation as well, right? About the. Adi question madidra?
That is the reason. Other cases where there is a mistake committed by the government, they have corrected it. In some cases, they have approached the Honorable Court, there was a direction. Some cases, but that is also forthcoming.
If I'm my lord permitted, my lord, the list which my learned friend is speaking about is the select list, my lord. The select list which was the regular list. These people came, my lord. These people came through the intervention of the government, and they were placed below the select list, my lord. From, if I remember, from 744, my lord. That is serial number 744. Yes, my lord. I just take your lordship to the page number, my lord. The page number is 9, my lord, 140, 141, 142, 143, my lord.
143.
Probably, my lord, 1 second. 147, my lord. If your lordship could come to 147, my lord, ಸರ್ಕಾರದ ಆದೇಶದಂತೆ ನೇಮಕಾತಿ ಪಡೆದ ನಿರ್ವಾಹಕರುಗಳು. My lord, what I have corrected is above 744. Above 744, up to from serial number 1 to 744, there was some mistake in roster point. One person came, my lord, I think 8 persons, E. Manjula and others, my lord, they approached this honorable court and they stated that the roster point is not correctly worked out. Only in respect of those 6 persons, there was an
And
order.
those were under the select list of 1992.
Yes, regular select list. They were
And not
appointed.
the probation, not the probation.
No. As per the advertisement, as per the notification and the number of posts available, my lord, as per the advertisement, is up to 744. In this 744, there was some mistake, my lord, in the roster point. Therefore, we could not have done only in respect of 8 people because there was only a direction to consider their case by the honorable court. While considering their case, it was found that the entire roster point was not worked out properly. Therefore, it was reworked. In this reworking, there is some shuffling of the probation. That may not cannot take that change cannot be taken in respect of the persons who are below 745 because they are only SC/ST candidates. Below 740, from 745 onwards, my lord, are only SC/ST candidates.
Yes.
So therefore, up to 744 is roster. It contains, my lord, the workman, my lord, the SC candidates, ST candidate, all categories, including general.
Yes.
744 onwards is the government list. Only SC/ST candidates, where we had taken them, my lord, on a temporary basis and we sought to discharge them. They failed, my lord, in the writ petition. If your lordship could see, I read the preamble in the writ petition, my lord, in the first, that is, my lord, annexure. If your lordship could see annexure D, my lord, annexure D, page number 62, in page 62. That is in respect of these people, my lord, in respect of the present candidates, that is petitioners. If your lordship could see 62, my lord, page 62, preamble, my lord. Preamble. Writ petitions are filed under 226, praying to declare that the petitioners are regularly recruited permanent drivers against existing clear vacancy as per the Karnataka State Road Transport Corporation Regulations 1982 and to direct the corporation to regularize the services of the petitioners, etc. This is rejected. Only the relief that is granted in page 69 is if they apply again, you don't apply the weightage criteria for them. That's the only relief given. Then they knock the then they knock the government, my lord. The government order, my lord, stated that to consider their case for reinstatement, against which, my lord, the resolution, the matter was placed before the board, my lord. The board passed a resolution that was reduced as a circular as at page number 98. In page 98.
Yes.
And in page 99, my lord, the resolution of the government, my lord, has been, the resolution of the board has been extracted, my lord. 4 in number. First is, my lord, these people should be placed below the, if your lordship could come to 99, page 99.
Yes.
ಮಂಡಳಿಯು ತನ್ನ ಟರಾವು ಸಂಖ್ಯೆ. Now, if your lordship, the first one, my lord, first condition, if your lordship could see, ದಿನಾಂಕ 14/5/93 ಸರ್ಕಾರ ಆದೇಶದಂತೆ ನೇಮಿಸಲಾದ ಆಯಾ ವಿಭಾಗಗಳ ಪ್ರಸ್ತುತ ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿರುವ ಹೆಸರುಗಳ ಕೆಳಗೆ ಇರಿಸುವುದು. These people, my lord, were placed below the select list of the regularly selected candidates. Therefore, I only intervene, my lord, because my learned friend tried to say that I have reworked the roster point and I have reworked the date of probation in respect of the same list. Therefore, they should also be given the same benefit. That cannot be given, my lord. Yes, I'm sorry, my lord. I interfered, my lord, when my learned friend was saying so, my lord, because we have not worked there. Only to that extent, my lord, I wanted to.
Last year, I'm not blaming the seniority over regular research. That's the law. Which of the other parts for this honorable court we are getting from service. Thereafter, which of the government order they are taken back. Now, my other friend Milot has made a submission saying that the delay in placing the confirmation. What is the reason assigned? He is saying that they are involved in default cases. Maybe the reason. The reason for Milot delay placing it them on probation is because they were involved in any default cases that will be one of the reasons. Then another ground, there was a delay by manipulation. Third ground is not that the only two grounds, I'm sorry, only two grounds for relevant as but as regards the default case is concerned. No doubt the guideline, the government order and then the board resolution makes it very clear if an employee involved in a department that has to be taken into consideration. By placing them on probation. Why did they make it place into this would absolutely belong to the board. But the really they are involved in departments. The first time belong to the board again. What is the second delay is concerned when you launch for client say why I'm referring this is. Suppose if I am claiming the seniority over the regularly selected candidate, if they are affected by H of Milan granting the relief to them, if there is a mistake committed by the corporation in implementing it because the board resolution they are running conflict with the guidelines what the board has decided, then in certain situations they are to continuous contract. Now you launch my guidance is government order. Sorry, the board resolution. I'm only reading only one paragraph. On page 100, second paragraph on the top.
Yes.
ಹುದ್ದೆಗಳು ಲಭ್ಯವಾದಂತೆ ಆಯ್ಕೆ ಪಟ್ಟಿಯಲ್ಲಿರುವ ಎಲ್ಲಾ ಅಭ್ಯರ್ಥಿಗಳನ್ನು ಕ್ರಮಾಂಕಕ್ಕೆ ಅನುಸಾರವಾಗಿ ಪ್ರೊಬೇಷನರಿ ಆಗಿ ನೇಮಕ ಮಾಡಿಕೊಳ್ಳಬೇಕು. ಪ್ರತಿ ತಿಂಗಳು ಆಯಾ ವಿಭಾಗದಲ್ಲಿ ಈ ರೀತಿ ನೇಮಿಸಲಾದ ಅಭ್ಯರ್ಥಿಗಳ ಕ್ರಮಾಂಕ, ಹೆಸರು ಇತ್ಯಾದಿಗಳನ್ನು ಕೇಂದ್ರ ಕಚೇರಿಗೆ ತಿಳಿಸುತ್ತಿರಬೇಕು. I will stop it at this stage every month. But whenever the employees were the list they were placed on probation, the list has to be forwarded to the head office. Then ಪರಿಶಿಷ್ಟ ಜಾತಿ ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಸಮೇತ ಆಯ್ಕೆ ಪಟ್ಟಿರುವ ಎಲ್ಲಾ ಅಭ್ಯರ್ಥಿಗಳಿಗೆ ಒಂದೇ ತರನಾಗಿ ನೇರ ನೇಮಕಾತಿಯ ಎಲ್ಲಾ ನಿಯಮಗಳನ್ನು ಅನ್ವಯಿಸಬೇಕು ಗಮನಿಸಬೇಕು. ಹಾಗೂ ಈ ಪಟ್ಟಿಯಲ್ಲಿರುವ ಎಲ್ಲಾ ಅಭ್ಯರ್ಥಿಗಳು ಕಾಯಂ ನೇಮಕಾತಿಯನ್ನು ಕೊಡಬೇಕಾಗಿ ಗಮನಿಸಬೇಕು. Now, lots of kindly see page 101 last paragraph.
From when did you, when were you appointed? 1993?
1993.
93. And you were kept in probation when?
In some cases in 95, 97, 99.
Yes.
Now, you lots of kindly see the last paragraph, page 101. ಎಲ್ಲಾ ವಿಭಾಗ ನಿಯಂತ್ರಣಾಧಿಕಾರಿಗಳು.
So your first probation ಯಾವಾಗಿತ್ತು? 1995.
95.
Date of appointment in the senior grade, the date of appointment, date of probation. Normally they will mention. They won't mention the date of confirmation. That's what the seniority want of probation. Now here, date of appointment, date of probation is one of the same year.
Date of that is what you have produced now. ಹೌದೌದು.
ಇದು seniority list ಅನ್ನು ಓದೋದು ಕಷ್ಟ ಆಗ್ತದೆ.
ವೆಂಕಟೇಶಪ್ಪ RM 5/4/1995.
In accordance with the list of the seniority. No, in some cases, 93, this is correct. In respect of first petitioner is 95, what they have mentioned.
How many petitioners are there before?
Now only 54 petitioners are there.
The first 1 to 54, yes. All the petitioners are before this court. This list which we have given.
Yes.
Yes. So you
now, your Lordship kindly say why I am referring it this way. Your Lordship kindly turn to Annexure. Annexure J page 101.
Prayer number A. Prayer number.
Page 109.
109.
109. This is the appointment order issued pursuant to the order for the board resolution. The serial number that this order is on 22/7/1993.
This was the appointment.
Now serial number 39. RM Venkatappa.
Yes.
Now 73 is the joint. Now in the senior actors they mentioned as 5/4/1995 date of joining. Probationary date what they have mentioned is 4/11/1995.
No, the seniority list is from the date of probationary, right?
No. No, what
Is it from-
seniority, I will claim seniority for the date of probation. That's total.
So let us not say
Date
about.
of entry, we are remembering this, date of entry is also relevant. Because an employee will get, that period is agreed to the statutory level. That period also.
No, that is for you to seek for correction in the records.
That is one of the prayer in this, that's what I have said, so, my application. Apparently, the date of entry into service also has been shown.
What is your prayer now in this?
Prayer
Is to assign the ranking to the petitioner in accordance with the select list. That cannot be permissible. Select list is.
Sign the ranking.
And not on the basis of the ranking list in the probationary list.
That is
Virtually what he's asking. He's asking same prayer what he asked in Annexure A.
Make sure, sharing is the nature of matter like responding.
ಇಷ್ಟೆಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದ್ ಬೇಕಾಗಿರ್ಲಿಲ್ಲ ಇಷ್ಟೊಂದು ಅದೇ ಅಷ್ಟೇ ಇದ್ದಿದ್ರೆ ಓನ್ಲಿ ಮಿಸ್ಟೇಕ್ ಇದ್ದಿದ್ರೆ.
If at all it is your mistake, we'll ask them to correct it. The date of appointment, you correct the mistakes.
One of the things.
That is one thing.
That is one. Correction of entry into service.
From the date of probationary.
Because this will not come in the case, if suppose if anything go on, they lose the case also. Let them not take the advantage. Say, no, no,
We will tell them, we will say that the correction of the date of appointment to be made in the records or pertaining to the petitioner.
All the petition.
All the petitions.
So, with reference to the-
Since it is 56 people, Melod, I will clear it. Kindly have it on Melod on Tuesday, Melod. I'll clear it here itself. Why it is done, Melod? Such a mistake would never be done, Melod, by the corporation, especially. And that too. ಇನ್ನೊಂದಿದೆ ಸ್ವಾಮಿ ಅವ್ರಿಗೆ ಗೊತ್ತಿರುತ್ತೆ ಪ್ರಾವಿಷನಲ್ ಸೀನಿಯಾರಿಟಿ ಲಿಸ್ಟ್ ಅದು ಸೀನಿಯಾರಿಟಿ ಫೈನಲ್ ಸೀನಿಯಾರಿಟಿ ಲಿಸ್ಟ್ ಇದ್ರೆ Melod, I'll find out. First time he's arguing, my learned friend is saying something which is not his case. So therefore, Melod, the same thing could be put an end, Melod. I will clarify because if he had said on the last date of hearing.
You have to say why a date of appointment has been mentioned differently in the records.
Yes, Melod.
When
I'll
the
find
date
out.
of appointment is 22/7/1993.
Yes, Melod.
Tomorrow, we will do it tomorrow itself. Again, Tuesday, we will again have to everything you have to.
Melod, what has happened, Melod? I'm not working, Melod, because I was unwell. Only for this, because it was dictation of orders, Melod. I think the officers have to come to my office, Melod. One day may not be required because I will leave now, Melod. I'm so sorry, Melod. Otherwise, I don't like to sit at home, Melod. I'm the last person, but I'm really indisposed. I'm not in a position to attend the court, Melod.
On Tuesday.
Or Monday also. Monday, I would have requested
Monday.
But I saw there are lots of cases. But Monday I will because since Friday and Saturday is a holiday, Melod. That's the reason I asked one day, Melod, on.
So let it be for dictation of orders only. For dictating orders.
On Tuesday, Melod.
Orders on Monday.
Yes.
To clarify that aspect as to why there is a change in their date of appointment.
Yes, Melod.
That is they can ask you to correct this.
Yes, Melod. Yes.
Yes, Mr. Peshwa. Yes, madam. Monday. For the day, Monday, Tuesday. Tuesday for the.
Number 80. Yes, Narasimha Swami.
Yes, Mr. Narasimha Swami. Correct. Why is it listed for further hearing? Petitioner sought time. What is this application? What was the order passed by the tribunal? What was the order passed by the tribunal? What was the application filed by, who had filed that application? What was the application filed? Thirty-three two B. Seeking for confirmation of the dismissal order. And that has been dismissed. On what ground? They have not complied the mandatory provision. Ah. Ah. So the caste verification, PCVC is the only authority to consider the caste certificate.
Lordships kindly,
What is
I'm not keeping well, my lord. I'm not able to address argument. Kindly have it on Monday, my lord. I will be all right and I will come to court and address the argument. This was,
Please,
my lord.
We have already heard you, right?
Yes, yes. This was heard during your lordship's first tenure with the labor matters, my lord. Thereafter, my lord, when it was listed on the second time, your lordship said it has to be heard once again. So matter did not reach on that day. Kindly have it on Monday or Tuesday, my lord. I am ready. Today I am not able to address arguments, my lord. Want to come to court and address arguments.
Correct. We will see. Now this court has to recollect everything, right?
That's why I will commence from the beginning, my lord. Monday or Tuesday. Tuesday would be ideal, madam. Most of them.
Tuesday.
Most of them. I'm sorry, my lord. Sorry.
Yes. Is your senior coming? Yes. When will your senior approach the spot or come to the spot? So we have to wait till your then. Yes. Wednesday. Yes, what is that? Yes, why was it listed for further hearing? And why did, I think on the last occasion, the petitioner counsel did not be present. So an observation is made that he is not present. Let us hear him once. Because we had not heard him on that occasion. We had heard the respondents. Correct. Yes, what was then? Yes. So we will pass orders. Yes, we have passed over, no? 10. Yes, Mr. Swami. Yes, they have to go before the miscellaneous appellate court. 5A order. Tahsildar passes an order. Tahsildar. The alternative remedy is available before the district court by filing miscellaneous appeal. Yes, you have to. You are coming against an order passed by the Tahsildar under the Karnataka Village Officers Abolition Act. So against that, there is an appeal provision provided before the district court. Come to section 5. Five. Then it is provided under section 3. This is any person aggrieved by any decision may file an appeal to the district judge of the district within 90 days from the said decision, and the said decision of the district judge.
Any land was granted or continued, respect of or annexed to village, obviously the state or whether any person is a holder of a village office, or whether any person is a authorized holder, or whether any person is an unauthorized holder, the deputy commissioner, so and so. So this order does not pertain to any of the four clauses.
Then what is the clause which is available to you now? What is the clause?
It's clause dismissing my petition for restoration.
What?
For restoration of the land. It has been
Restoration?
sold.
You're the holder.
Was granted.
Then
That was granted. Then my power of attorney has sold the land within 15 years. Prohibited period.
correct.
Then section 7A comes into play. Lordship mechanics 7A.
Okay.
No person shall transfer or acquire by transfer for a period of 15 years from the date of regrant. Regrant is on 2006 and the sale is on 2008. Read on or up to the date of commencement of the Karnataka.
This is available for you to be urged before the appellate court. All these grounds are available for you to be urged
It
before
is
the.
not maintained.
Correct.
The order is question of delay in filing the application. The question of delay will not arise.
Question of delay has to be adjudicated before the district court itself. How can this court in a writ petition by bypassing the appellate authority to come before this court in a writ petition?
That is when the four clause A, B, C, D. If there is an order in this aspect, in this, any of the four, then an appeal arises, not otherwise.
There was a land, according to you, granted in your favor. Is it not? The power of attorney has sold the property.
Yes.
So according to you, he is an unauthorized holder, or whoever is in possession of the property is an unauthorized holder.
The sale is bad.
Yes.
Section 7A says the sale is bad. When the sale is bad, what happens? The consequences are so described in section 7A.
Your application was rejected, right?
Not rejected. It is only saying you come before the authority time bound. That is all.
What was an application? What was your application before the Tahsildar?
Sale is bad. He's in contract.
And why did you go to the Tahsildar? You should have approached this court directly. You should have not gone to the Tahsildar if this provision is not available to you.
It is only
If you have gone to the Tahsildar or the Deputy Commissioner, but in respect of the Karnataka Village Abolition, Offices of the Abolition Act, in regard to the sale which has been sale by the power of attorney is bad, then in that circumstances, why did you go before the Tahsildar?
section 7A.
Then when that is there, when you went before the Tahsildar, then you have to file an appeal against the order. Yes.
If there is an order, whether the land is granted or not, then yes. Whether any person is a holder, that is not in dispute. Whether I am an unauthorized holder, no.
Yes.
That is, those things are not in dispute. Only when those things are in dispute, then I have to, the provision of appeal lies. Not otherwise. You see the order.
Which is that order annexure?
Like
Annexure. This is a petition or the application filed under 5.4. 5.4.
Explore the land in question by setting aside the sale in each in favor of the respondent. So instead of passing an order at the
So
section
you are
17
seeking for restoration. You are seeking for a restoration under section 5A, 5.4.
study for regrant. Regrant will arise.
Where is the question? Where is the question of regrant now? You're seeking, regrant is already there in your favor.
No, that becomes null and void. Your lordship, is 7A, madam. 7A fully may be read, madam. 7A. No person shall transfer or acquire as by transfer for a period of 15 years from the date of regrant, made on or after the date of commencement of the
No
Karnataka.
person shall transfer or acquire by transfer for a period of 15 years from
Yes.
the date of regrant made or after the date of commencement of the Karnataka. So the criteria is there has to be a regrant.
Yes.
There has to be a-
Subsequently. After that, madam. Or regranted under subsection 4, 5 or subsection 3 of 7. And any transfer, here, madam, and any transfer of such land in contravention thereof shall be null and void. So the transfer is null and void.
This is in pursuant to a regrant in your favor. Then if you tell there is a sale within the 15 years from the date of regrant, then the sale would be null and void.
Yes, after the regrant only 2006.
Now you said there is no regrant order.
Second regrant order. Second, first regrant.
No, first you have to, there is a regrant order, right? Huh.
That is what I said in 2006.
No, you said that there is no regrant order now.
Regrant order is there. And 2008 it is sold within 2 years. So within 15 years it should not have been sold.
Yes.
Any transfer of such land in contravention thereof shall be null and void. The land so transferred shall vest in the state government. So now the lands should stand vest with the state government, free from all encumbrances. The provisions of subsection after the vesting, it should be granted to somebody. So it should be re-granted to me. That is what I asked for.
Yes. Yes.
That
The land was re-granted
18.4.
Thereafter, the grantees are equally thereof availed on 21/6. And thereafter, the government users have sold certain properties based on the power of attorney and their intention and properties. As such, they approached the properties of PCL Act also. The segment PCL of the government PCL Act, again, they approached this seeking cancellation of the grant, but that to them, including possession. Then, Russell Bandit page 6. The last paragraph. Further completed the legal year for the question regranted 9 years away. I from the meditation have twice the application before Mr. Receiving permission to serve the land. And Mr. God has granted state permission on 8/11/6. And the regrant of and the regrant is
Where are you reading? Page 287, right?
286.
not paragraph
Ah,
of the order of national.
yes, yes. Has filed an application before the authority seeking permission to sell the land.
Set the line. So granted on 8/11/3. And the common members of the future agreement dated 24 those are there. Then, Russell had taken the consideration of to begin like access on a part, approaching the Sridhar.
When was it? When did they approach the Tahsildar?
2021. 2020.
20. Yes.
The sale is of 2006. For that, applying the principle of trade-off. In second Ram Lakshmi to it. Because I have done
Yes.
So, that applies, not the heavy loader.
Yes.
It's not working like this. You are sought for restoration of the land and also restoration of the possession from the non-document. Not that case that option to be the GPA and what I mean. There is one more this more than year 2009 except that was converted for the town.
What is that?
Here, like it's
Ah.
and was converted for non.
Section 3 states under what condition the powers of the deputy commissioner to decide the matter. So says whether any land was granted or continued in respect of or annexed to the village office.
The land was granted or consumed for the
With
so that means this is the name and was. Whether any person is the owner of the office, whether any person in another order now is the person, which is 7 years. Whether any person in another order is because there is of property in another order.
yes, that is what we said.
That's all. 7 years, not any.
Was the power of attorney cancelled? No. Then we will take it. It was not cancelled.
So already school. After of cancellation did not arrive.
Yes, that is in the year 2006. Yes.
Immediately, the inception of the executed GPA for the development of the farm. So that it's a beneficial legislation, they did not go for improvement of. They wanted. They said that they executed GPA for the development. The GPA holder who received the signature, all of them will submit what executed a sale agreement. And what executed registered GPA and also sale agreements. And also from the registered GPA, sold the property. So we believe.
So he is making an allegation against the GPA holder as well.
Making allegations that he was all to develop the property. He did that for development. But recently they came to know that the sale transaction happened. This is the relation between now other three. Delayed matters of the main contention for the second factor. He did not release a lot of they cannot say within 15 years that middle after the same year they say this one, they change in the revenue. But the approach with the passenger, question the.
Now, when did they question that entry? 2009. The entry of the name of the purchaser. Purchaser. Yes. We're reading 287, right? Third para, huh?
Of the legal significance and objection for the transfer. Seen the social norm of the legal action, they are also for the state government, also being making. He also went back near day of office. No, Malay just to take the shelter in such time, he said, permission. There's also observation is a permission. Everything is mentioned in the.
Yes.
So, Malay, we have to go on the deadline classes. Because the second Malay is that the grant is no, the grant is. And say, the grant is that annexure is the legal order. Practice. Only whether there is some success or expert. This state
Yes.
the legal was writing for the that they granted several lands. So this additional document GPA to find an annexure page number
Page number 36.
36.
Yes.
There are 27 processes to execute. The content is that there is some other practice to accept that they are no place and they are not to question is alien. So only some person has come up with the grant is other regulations part of the party residence. And also an argument. It's center act. It's not prescribe any limitation. So that the question of limitation cannot be taken into consideration. That is in the clear. Under the
According to them, there is no provision in the act to restoration. Now he is seeking for a restoration.
Directly about the last two lines. But notice that directly last line there are the land affairs change for both. Putting all this in the field, it still not the definition of the reasonable time of loss of the best. After a reasonable time is coming to which the act doesn't the definition of quantum knowledge, the meaning of the dictionary, that is the paragraph.
Yes, yes.
That is the reasonable time that is reserved to each party, the rights and advantage he possesses and each party for the process that he owns not to suffer. So the reasonable time for not only for person who benefits but also the person.
Yes.
What I'm doing is time of the return is never enough. What there is a part. But people protect the office of that whether an action has been taken, he gives them a time of one of the party who might suffer. No, there is no way of limitation. That must be taken. There are two more of an application. Very reasonable. Reasonable time depend on the purpose of each case and the purpose of the case before us. That clear that the action is grossly delayed and taken beyond time, particularly beyond the fact that land was government during this period. Obviously, there that is not covered for years. Here of the reason because no limitation. The right accords and purpose cannot be from those things cannot be initiated after it's they may contain it's a beneficial legislation will object your beneficial so limitation not out there. Second issue is also on the case of fraud. But the content was getting cleared by fraud by one of the persons. There will be developed
Permission was obtained from the deputy commissioner for letting complete.
The point of the also for the government authority. The government of all this. Calculation of they don't need to see report of the same authorities.
Yes.
So this is just for the judgment. There's a case of fraud. And the content is more case of fraud. It's also part where the any point of time. You said that any point of time was actually page number 14.4. Parent taking point for consideration. Whether exercise of so much of power that is subject to take these or that has to be in reasonable period of that said all it can exercise in any reason. So the parent nine. So because the implement of or it could take place. It's reasonable time. The particular here as regards fraud, the date of discovery fraud, also in the period from the date of also the attention that the two more fraud be executed. This is like giving a region of that from the date of discovery fraud was not done. The earnest immediate as well as the beginning of the date of the very not covering the cost of fraud, I think do the horse at any time for that only indicate that those specific two model power would be exercised. That means not starting from the particular date. But then exercise of so much power depending on the prices. Or the exercise in a reasonable or secure everything. Like exercise transform, but exercise transform, several factors need to be kept in mind. Such as effect on the rate of the third party or the more due to package of change of hands by subsequent. The office obtaining penalty under the clauses of the attack. Hence, the coverage the report stating from what date the period what period because the range and abuse for the two more cost is very reasonable. But the date of discovery of the product is possible. They also always make the fraud. The patent fraud for the TQ or the patent. So they are not mentioned. Date of discovery of the product is better than volatility. According to me, the approach for the application of the data. The pixel one of the conservation for
revenue records when he challenged the
Not direct. Yeah, again, went to the PTC and saying that it will come out of PTC in their 2012 effort. They did not challenge.
So even in the year 2012, there is an order against it. So even if 2012 is concerned, they should have approached the Tahsildar in a.
8 years for the 2020, they come out with this. So there is several issues, the same amount of six mentioned.
Yes, yes.
Last aspect, similar aspect also. Keep on for this. This one the paper that is point of limitation that for same level the exchange himself is not very limitation and we cannot hold in the system and approach and say that the capital community is limited. This both judgment will therefore affect page number 68.
Yes.
Second observation was that the causes of limitation. The one observation was that likewise in the regulation. Likewise, the instance is the occurrence of any provision that the PTC and prescribing period of limitation. That's very article. But I did not find much illegal process. Ultimately, that was not accepted.
Yes.
So the only point about the yes. This is one Yes, para 36. The act does not consider any intent of the block back for a city of the law. It is in violation of the legislation. Here, if the question is one of the power being exercised by the authorities after long accepted reasonable manner, any directed point of right, grant such exercise of any more reason has been not correct. Then what is reasonable time is not capable of being fixed in a given frame. What is reasonable situation may not be reasonable in another situation. This is a power within a reasonable limit, always will be very statutory provision and the purpose and the object of such statutory provision. The statute intends to ensure that the benefit of the land is extended over a period. That provision protects not only also doing very mistake that may occasion will lead to defeating the object of the effectively that does not for failing the assistant commissioner, the action is very small but violation of very good. For assuming and requiring the land for land of the land consequences. Something more. You know, all different sort of law one floor. Attention of this road is
Yes.
Excise is referred to the terms of section, but the interested party to it does not in case of Devila.
Yes, yes.
Devila Yadav was
That is now all similar proposals. Yes.
So that will depend on the type of They want immediately 3 months of the executed TP and then just wait until they want to be not developed. That means the purpose of the object of that will not come in the recently our government has also and then you got the extra limitation.
Yes. Yes, sir.
We always under the limitation. That is of the
Limitation is different from latches. Yes. Oh. How many purchases after that? How many purchases after that? Earlier, first purchase was 2 purchases. And now layout has been formed. Now again, which respondent has to answer now? Mr. Vasant, you appear for? 3 and 4? Who are 3 and 4? Hello, who is 3 and 4? The other? GPA holder. And you have sold this to 5 and 6. Sold. Purchaser. And who appears for 7? 5 and 7 you appear. So 6 is, how is it connected to this petition? Purchase. Sure. Yes. 4 as well. 4 as well. So purchase. Only 3 is the GPA holder. And you appear only for 3. 4 is a purchaser. But the GPA sold it to 4. Yes. Yes, Mr.
All the judgments relied upon is not directly concerned with the KPO Act. But the Supreme Court judgment they are relying upon. It directly deals with the KPO Act. And what happens when there is a land which is sold within 15 years of the prohibited period, it has to rest with the government.
That is the proposition.
Yes.
Now, yes, you read.
So it has to rest with the government. Not the case going to be re-granted. It has to be re-granted subsequently after the vesting, not before the vesting.
Yes.
So the question of limitation otherwise will not arise.
At any time you can challenge that. At any time.
I am not challenging. It is for the government.
Yes, yes.
It is for the government. So what? There is no application I can make.
This, if there is no prior sanction, question is whether there was a prior sanction from the Deputy Commissioner. That is the
Grant is there. Grant is there. That has
permission to sell the property.
that is not valid permission at all.
Did you question that valid permission which is there? Yes, you read this. Which is that you want to read?
But taking careful consideration the above submission, hold that the contention above state deserves to be accepted. Section 5 of the Amendment Act of 1978 reads as follows. The occupancy of the credit money part of land as may be re-granted under subsection 1 shall not be transferred otherwise than by partition from the joint family for a period of 15 years.
This Lakshmana Gowda's judgment applies here, right? Lakshmana Gowda's judgment says that if there is a sale after the Principal Act coming into force and between the year 1978, if there is a sale and if there a prior permission is taken from the Deputy Commissioner, then the sale becomes valid. And even if no permission is not taken, he has to pay 6 times, or the holder of the land has to pay 6 times of the assessment, and the purchaser or the alienee have to pay 15 times of the assessment.
That would apply prior to the Amendment Act of 1978.
So even yes.
After 1978, this embargo of 7A comes into play. 15 years, no permission can be given also.
Yes.
So the permission, even if it is granted, is not correct. That is what in Lakshman Gowda's case it says.
There is a clear prohibition under the above provision that the re-granted land shall not be transferable for a period of 15 years from the date of commencement of the Act 1978. The effect which is for a period of 15 years, the statutory elimination. In fact, Lakshmana Gowda, Sutra in para number 87 has said, in light of the above principles and statutory constructions, we hold that the principle should be considered as applicable only to transfer made subsequent to 7/8/1978 and not transfers which are made prior to. Yes.
So no transfer has taken place even on 7/8/78. On 4/12/78, the transfer takes place, so it's void. So section 7A, the land vests with the government, not to anybody. Then only it has to be re-granted to somebody.
Yes. The permission was available before amendment. After amendment, what happened? 15 years. Section 5 says 15 years. Section 5, subclause 3. For a period of 15 years from the date of pre-grant made on or after the date of commencement of the Karnataka Limited. This is the occupancy or quarry patta of land, as the case may be, re-granted under subsection 1. Subsection 1 is the re-grant here.
Yes.
So then shall not be transferable, otherwise than a partition. So only a partition can be effected for a period of. Who has paid this 15 times the amount? Who has paid this? Correct. Deputy Commissioner, sanction can be given and payment of an amount of 15 times the amount of the full assessment of the land. What happens in the absence of any application filed by them under 5(3) of the seeking for restoration? What happens? What happens? No, what happens? No. What happens in light of this provision? What happens? If there is a violation and the sale has taken place during the non-alienation period, what happens? Is it necessary to be questioned? 7A, what does 7A say? It says no person shall transfer or acquire.
When they acquire, they are liable to punishment also. The clause 2 says it.
No person shall transfer
Or acquire by transfer for a period of 15 years from the date of re-grant.
You come at 2:30. You have to look into those provisions say, what happens to the 15 years? Whether an application needs to be filed by them in the light of this provision under section 7A. Yes.
Court officer?
for matter, listen to. Then number 1. Plus GB.
Yes. Correct. How is this maintainable now before this court? You have to go and approach the. Correct. There is an order passed now by the trial court. You have filed objections. You make a necessary prayer before the trial court. Correct. How is it maintainable before this court? How is this petition maintainable? You have to make an application for vacating the ex parte order or file an objection, or is the application considered now? Is the application allowed? Then what judgment? It says even if when the matter is pending, you have to consider this court has to consider and pass an order ex parte, another ex parte order in this writ petition. Yes. Is it so? How many times to pass over, Mr. Counsel?
Number 12.
Is Mr. Ajay Prabhu? No representation in the morning session as well as in the afternoon session. This is the matter for discussion. Yes.
Number 19.
Yes. 30% is the diminution. Yes. Now coconut trees, how much? Yes, correct. Yes. So as per the trial court, this is all as per the trial court calculation.
Except for item number 2 and item number 3.
Number
Item number 2 and 3. One member as per Karnataka's judgment.
correct, 30% has to be taken. So 30% would be the appropriate case.
The remainder members I have not what we can make.
No, coconut trees. This court has consistently held according judgment. This court has consistently taken for one coconut tree at 12,600 for per tree. No, but then these are all standard formats, right? Now we have been consistently taking this as 160 and the number of trees and the husk value and diminishing the 30%. Is it so in the evidence? Is it so in the evidence? See, let us not waste our time into as to how much, what was the. Now, if it is an undisputed fact, let us not involve into all that. Now, the coconut trees have been shown at para number. Para number 18.
About the 18, taking the maximum yield of 1 7 rupees is taken.
One tree, what is the calculation taken? Not the yield. One coconut tree, what is the valuation?
One coconut tree is 700. Point number 1. Taking the maximum yield of 1 tree.
Where do you get it?
I got para 18.
Ah.
The First, page 17, internal page 17 of the award.
Yes,
Taking the maximum yield of one tree at 100 coconuts and 7 as the moderate price, the annual yield expected from one tree would be 700. Therefore, my lord, instead of 50%, 30%.
so how do you value a tree? How do you value a tree?
The yield into the number of coconut trees or number of coconuts per tree into the price of coconut.
So this maximum yield for one tree, 100 coconuts is for how many, for what, per month or per year? Per year, per annum. Yes. So one tree, 100 coconuts, and for how many years? 10 years. Huh?
For one tree.
The age of the tree.
Age of the tree is 10 years.
So 10 years. So 10 years, if you take the calculation as, there were how
And
many?
7 trees. 7 trees. Point number 3. 7 trees.
There were 7 trees.
7 into 700. Per tree, the yield is 700.
That comes to
7 is 49,000.
49,000.
Now 30% of this.
30% of this less.
Yes, sir.
It comes to, where is your calculation?
49,000 into 30% is
How much is?
14,700. So 49,000 minus 14,700. That comes to 34,300.
14,400,
700.
700. So it comes to
34,300.
34,300 as against 27,000. Then the neem tree.
They cannot neem tree is 18 neem trees 90,000 is award.
19,000.
Item number 5 in my share is memo.
Now, how much is one neem tree considered?
I got spell neem para number 90. That internal tree is 80. I got 5,000 is per tree. Para 90.
Per neem. So how much is considered?
5,000.
5,000. That is correct. So 5,000 into 18 comes to 90,000.
90,000. Then Jolly tree, my lord, just below the neem tree, my lord, 5,000.
How many tree? One tree, no? That is also correct. Next. Teak trees.
Yes, madam. For teak trees, my lord, para 20. My lord, you will get it at bottom. Again, my lord.
Teak trees.
For 6 teak trees, we get 10,000 into 6.
It has to be taken as 15,000. 15,000.
Oh, my lord, the timber, they make the teak
Neem tree,
oh, my lord.
teak tree.
In fact, by respect to the position, my lord, all these, my lord, they take the timber with it. We don't take the timber because when we draw lines across 4 such lines, my lord, we don't take the trees and go around.
So how much is that? 90,000. 30,000 is granted.
10,000 per tree is granted.
Yes, we will take it as 15,000. Next, bunny trees.
Bunny, my lord, is 2,004.
How much will it come to? How much is that?
Paragraph 51.
What is the reasoning?
Oh, yes.
Bunny tree, 4,000. 4,400. Only one tree?
Yes.
5,000. We'll take it as 5,000. Yes, calculated. 34,300. Yes, coconut tree is, you said it as 34,300. But you are taking the yield as 700 per year.
And the total is 34.
Yes, 34,300.
Then my lord changed
Neem tree is
90,000.
90,000.
Jolly tree is 5,000.
5,000.
My lord
15,000. 15,000 the per tree. 90,000. 90,000. And then 5,000.
That is the recalculate.
Yes. We have to add husk to the coconut tree, right? Husk of 5,000 is usually added.
So a timber of 7,000 is added also. There is no timber, but husk is
No, husk for the coconut tree.
5,000.
Husk for the coconut tree. If you add husk of 5,000, just add 5,000, just a moment. 49,000 plus 5,000 comes to 51,000. Then deducting 30%, what comes to 51,000 of 30%. 30%.
15,000.
15,000.
15,000. 35,700.
35,700 plus 90,000 plus 5,000.
I just calculate from item number 2 now. Madam.
Yes.
I am doing the
90,000
plus 1,141.25 plus 4,000 plus 35,700 plus 90,000 plus 5,000 plus 90,000 plus 5,000.
Yes.
So it's, and this comes to 2,70,840, 2,70,841.25.
How much has been awarded?
I was in this item number 1 must be deducted. I have already paid. I got 1,20,000. Item number 1.
Item number 1.
2,70,000
Minus 1 lakh.
841.25 minus 1,20,000 154.
What is the total amount which has been arrived now? Yes. 5,000. 90,000.
150,87.25.
What is the total calculation after calculating and after deducting how much?
So my lords, 1,50,000 87.25 scale.
87.
That has to be modified.
And what is the total figure arrived? First
total figure as per my lord's calculation is 2,70,841.5. And in that, after deducting 1,20,000 154
already paid.
1,50,000 87.25.
What is the amount? 1,50,687. Where is his?
So respondent, the number 90.
How much did he say for the coconut tree at that point of time? Did he say anything about the coconut tree? Did the claimant say anything?
On the market value of the corridor. That was his argument. This is the guideline value for the tower and the.
So that is there. That is the prayer in his writ petition now.
His writ petition, the challenge is the award including his paying for a or figure without any.
And what is the petition of the another? All the 3 petitions are filed by 2 petitions. It is not connected.
Not of the same rock.
So his grievance is regarding corridor now. Now what has been held regarding corridor? 5.5. According to him, it is 18 meters. How does he substantiate it is 18 meters? Is it correct? He has to be given 18. Huh? Then in this also it has to be modified then.
He has not disputed it. And he cannot dispute it here, my lord, when my lord has given the
Right. What is not disputed?
Yes.
Para number 13.
13 at page 11, internal page 11. And also, I agree. The petitioner has stated that nearly 4 acres of land has been utilized for drawing the electric, but there is no proof for that. On the other hand, the document produced by respondents at R1 discloses that they occupied an area of 57 quotas for drawing the electric. This is not disputed by the petitioner. In fact, against R1 was marked with the consent of the petitioner. Therefore, the petitioner is entitled for compensation in respect of this 36.57.
And now what he says?
Now he says, no, it should be greater.
Greater to what extent? On what basis does he say it is to be more than that?
He refers by Mazar. And he says, by Mazar itself, there is a greater extent of corridor area also should be considered.
Where does it show? Where is the Mazar?
It's at the exhibit. My lord, you will find that at exhibit.
The bit?
But there is, he produces a memo before this court.
And memo for it?
And he relied on the memo last time in the argument. And from that memo, he says that the corridor area is really considered.
Is that memo? It is found in the records. Is it found in the records?
It's not exhibit memo. It's not a finding fact. That is my dispute is that there was in a case where he might not place.
I don't know why the consuls don't appear when the matter is closed. And this is being passed over for the second time.
It's has to be redetermined. These matters were remanded back to my hospital.
If he is taking a contention that the corridor area is not been considered, then for that reason also we have to demand the matter.
Partly raising this food in several cases. I would like to draw my lord's attention to matter 15 of the award. In fact, the trial court also ruled, and this court has held my lord that cannot be conditioned.
15.
Para 15, my lord. My lord, she find after coming to the next aspect, cutting and removal of trees. The petitioner stated in the petition that the respondent felt so and so tree. The respondents fairly admit this fact by filing exhibit R1 memo.
That is what.
But for this is important, my lord. But for assessing the compensation towards that, petitioner has not produced any evidence. So without basis without bearing any evidence, because they could not have been.
These trees, without these trees being cut, you cannot put the line, electric line. Can you put this
These are cut, that is in this.
Then
the only thing is as regards compensation, when is the but for assessing the compensation.
Then the trees have been cut.
That is why my lord, in several matters of this nature.
But now, in this case, it is usually in such big trees. Without cutting the trees, you cannot lay an electric. Oh, it's only regarding the corridor area. Just to pass over, let him come. If he doesn't come, we will pass this order. We will say that he has already accepted it. Yes, already happened. And in your matter also, he has admitted. Yes, we will see password. No, no, you were not present. How do you think the court will wait for you for 2, 3 times? Correct. How long will you be held up? From morning till evening? No, no, we are not going to take your matter. No dismissal, it is already posted. Is it justified on your part? So we wait in the morning, we wait in the afternoon. So you wait only till the court, you see the court, you watch the court, you see whether the court is really going to dismiss your petition for non-appearance. And then you make your chance, you take a chance before the court. Please don't do that. Don't do that. Correct. You have not even filed an application.
They are alive.
They are alive. What is that? We have dismissed the application. See, finally, a week's time is granted to take steps for the issuance of notice to respondent number 10 and 16, failing which the writ petition stands dismissed as against respondent number 10 and 16. Yes, what happened now? Two 11.
Number 4 and 5.
211. 6 to 8 abated.
They are not taking.
Where is your affidavit to that effect?
I filed application recalling that order was order dated 21.
Respondent number 6 to 8 should stand abated.
Application dated 29/18/24.
And what is the application you have filed now?
29/18/24 was recalling the order dated
29?
8/24. So recalling the order dated 21/8/24. Stating that we not
IN number?
IN number was 1 of 2020.
1 of 2024. Recalling the order dated 2/11/2017. The 7/12. See, 7/12/2017 is pertaining to respondent number 10 and 16. It is for non-taking steps. Non-taking steps. Now, what is I1 of 24? Which is the order you have filed for recalling? I4 of 2024 is filed under section 5 of the Limitation Act to recall the order dated 2/11/2000.
5 is for recall the order dated 2/11/2017.
No, iదే 2/11 ಅಂದ್ರೆ ಒಂದೇ order. I5.
Abate ಮಾಡಿದ್ದಾರೆ. Abate ಆಗಿದೆ.
2/11/2017. 2/11/2017, the petition R6 and R8 stands abated. R6 to 8 stands abated. Have you stated in your affidavit? Then when an order was passed, why did you not mention this? No, whatever NOC, whatever it is, Mr. So when you take a NOC brief, You should know as to what is the order and what is the actual facts. Is it not when you file a recalling application? This may so much of waste of time of this court. Mr. Consul, this I-1 of 24 is filed to recall the order 7/12/2017. You should know which are the IAs. So kindly mention what are the IAs and look into. We want this court to do the entire exercise. Then please do it. Okay. Yes. And what is it? Preliminary hearing B group, no? 230 matter. Continue now, lady, 21.
Number 21. NBN Swami.
Yes, Mr. Sampath, what happened?
Several years for the recovery.
This is a matter not of the year 1978 or 66 or after 2006. This is of the year 2006. There was an order of regrant in favor of the petitioners. The regrant order said 15 years non-alienation clause. So he could not have sold the property for whatever reasons. Maybe he is being pleading now fraud or whatever. Now, in light of the non-alienation clause, the sale deed, what is executed in favor of any person becomes null and void. That is how whether an application needs to be filed in light of section 7A. No, what does 7A say now in this order? What is act? So it is now declared as null and void. Now, in light of this order now passed by the Tahsildar, what happens? No. Now what happens now in light of that order? Would be ineffective. The order passed by the Tahsildar would be ineffective. No person shall transfer or acquire so and so and so any land disposed or regranted under section 4 and 5 or subsection 3 of section 7, and any transfer of such land in contravention thereof shall be null and void. The land so transferred shall vest with the government free of from. So now there will be this land will be vested with the government. And the provisions of subsection 5 of section 5 shall mutandis apply to the transfer of such transfer. So what does 5(5) say? The person who acquires by transfer such land in contravention shall on conviction be punished with an imprisonment. That is a penal provision.
The state is really. It is for the state to say you are initiating. It's still David check what is it? Because the clause in space, the regulatory act has the power for any state to seek exemption. For the state, if the state has not done, to seek number exercise that power can also not be personal limitation of the power. The state is silent. It did not take any action. Action not the section 7. This signal case here is facts of that case but then
That was before the amendment.
Permission. Say, I have a permission.
No, this is not a case prior to 1978. So question of all this contentions of yours would not arise. Now this is a sale of 2006. The grant also is of the year 2006.
In this case, what has happened? Because the amendment came into place, the allegation of the date of the amendment, that is 1978. The allegation is that when after 15 years after 1978, then the allegation was.
What they said, if it is after 78, then the amended clause, that is amended to section 3, 15 years is incorporated. Earlier it was prior permission, now it is 15 years. So it was set at naught. Up to 78, you were given some liberal constitution. Only some liberal point of view was taken from 66 to 78, not otherwise.
Case also it is not legally approach and said the allegation is Tashindar initiated should have initiated. Stated that all that has been so.
Correct. Now it has to be resumed to the government.
But the government has not taken any action. Government
Where is the provision for the government to take action in this? No, that is eviction that they have to take in accordance with law now. Now if the court holds that the order of the Tahsildar is bad and the sale is to be held as null and void in light of the contravention of section 7A, then what happens is for the respondent state to take action. That is not the question here now. You know the law now. Yes. We all together have read the provisions. No, there is no resumption. It is automatically resumed to the government. Automatically. There's no question of even if I don't know why did he file an application also before the Tahsildar to get this order.
Says government and has to dispose of
5-4. Allah, that is what any transfer of land is in contravention of subsection 3 after the Amendment Act shall be null and void, and the land shall so transferred shall as a penalty be forfeited to and vest in the state government free from all. So nothing, this automatically everything happens. So there is an automatic provision there. There is a grant in his favor, non-alienation clause. He sells the property. Once there is a sale between the non-alienation period, then it becomes null and void automatically. Then 7A is attracted. Then it resumes to the government. Then the government has to take possession. No, that is now that you can do before when the government takes action now. No, this is all now. See, we need not go into anything, but the provisions of permission is not necessary now here. No. That is, so there is one provision. Earlier, before amendment of 1978, there was a provision that you have to take a permission, that is the holder has to take a permission from the deputy commissioner for seeking permission to alienate the property. And that was set at rest after the Amendment Act of 1978 coming into force said, No, that also is not necessary, but a 15 years non-alienation clause was provided. No, it's not available. Hmm. Andre, after this, you have to take a permission and then pay an amount of 15 times. Correct, with permission. And you have to pay 15 times, whether that has been done yet. And whether you have paid 15 days, merely permission agala, you have to pay 15 times the amount. After hearing, no. Now, after hearing the matter, see, we have heard this, we have understood, and you also have understood as to the scope of the own levy. 15 times. That is again the criteria of this Lakshman Gowda. You may not forget, but this court will definitely do it. This is a permission and without paying that amount. See, look at this order. There's no permission also. Yes. Whether it was granted. Okay. So where is that order at least of the deputy commissioner? No, that is all the order of the Tahsildar, which doesn't find place on the materials produced. Correct. That is why it's all or either they did not follow the order, or they felt that this is the order, or they on own they have incorporated in the sale deeds or in the order of the shipment. Does that mean there is an order in that order? This is that order. Claim that is the order. So at the top of the list. For the really. In spite of there being free sales, you have no very limited. Yes. Next one. Yes, 230. No, Mr. Spurti Hegde, how do you come to the court? You don't even come in the first hour. You don't come when the matter is called. How much time we should say this? So you be there only. Don't come to this court. Don't come to this court. Then you don't have any other colleagues who can represent a matter here. We have to hear the petitioner. Either in the morning, both of you all are not there. In the afternoon, when we take the petitioner counsel is the respondent is not there. How is the court going to function this way? Just tell this court. Yes, you make it at the end of this. Yes. Let him start. Let him start. Senior counsel, which matter? AG? Okay, Jim. Which one? You come in 57. You're appearing in 57. Yes. Yes, yes. This is serial number 56 or 57? 57. So 57 and 58 are similar? No, they are again different. 57. Yeah. Yes.
System of report or right to when direct and body in the system. Direct and body are different.
Yes, first, let this court know what you are challenging now before this court. What is the impugned order?
Refund of the money already deposits.
Refund of money.
To apply customer fee and give benefit of payment.
Adjustment. Yes.
The petitioner was given the right to rent analysis. He go the order and petitioner followed. What I hear, 2002 3-4. It is annual process. But in the month of April, May, the deputy commissioner requiring for auction. Whoever is a successful bidder is a, it's right.
2003, 2004.
Condition is that bid amount equivalent to 1 month will be deposited in cash. And for remaining 2 months, the commission security by your property. That there was some problem. All right.
Yes.
That is done. There was a delay in making compliance of fixed for 1 month. Consequently, the lease was terminated and fresh option was set. However, the procedure is governed under the Karnataka lease of the retail kind of higher goods. When consequent upon the default, the lease was terminated, fresh option was set.
This was for the year 2003, 2004.
Fresh option. The bid amount is still lesser than what is offered, that is 2 lakh, 19 lakh, 45,000. The defaulting contractor is liable for loss. Why it should be compensated by co-existence of the unmet default. In this case, The petitioner made several recommendations. Published the attaching to the compliance of way. Subsequently, my lord, from time to time, the government of Karnataka is not the one case. There are several hundred of police cases may be there. In which a single nature, the quality contractors. Some of them died, some of them have seen. The government wants to recover somehow and from time and again. It needs to introduce a scheme called Karasadaman among other schemes. That means, in the event the contractor comes forward, deposit the principal amount due. He will not be liable for penalty or interest. Like in the sales tax or other revenue. In this case, the petitioner has made recommendations. It was not considered from the latest scheme of the Karasamaja scheme 4. It has not been considered. On the other hand, the notification dated, the order dated 2/20/2024. Annexure A has. As a new annexure A.
Yes.
Page number 32. Deputy Commissioner Procedural ಪತ್ರ ಸಂಖ್ಯೆ ಎಂಟರಲ್ಲಿ ವಿನೋದವಾಗಿರುವ ಅಂಶಗಳನ್ನು ಕರ್ನಾಟಕ ಆದೇಶ ಸಂಖ್ಯೆ ಇದು ಮತ್ತು ರವಿವಾರ ಮತ್ತು ಕರ್ನಾಟಕ ಕಾಲಾಯಿ ಮತ್ತು ಕೇಂದ್ರೀಯ ನಿಯಮಗಳ ವಿರುದ್ಧವಾಗಿರುವುದರಿಂದ ಹಾಗೂ ಪ್ರಸ್ತುತ ಪ್ರಕರಣದಲ್ಲಿ ಸರ್ಕಾರಕ್ಕೆ ದುರ್ಬಲ ಮಾಡುತ್ತಿರುವ TMP ಮತ್ತು ಅಸಮೂಪಾಕ್ಕೆ ಮಾತ್ರಕ್ಕೆ ಹೊಂದಾಣಿಕೆ ಮಾಡಿಕೊಳ್ಳುವ ನಿಯಮಗಳಲ್ಲಿ ಅವಕಾಶ ಆದ್ದರಿಂದ ಶ್ರೀ ಅಜಯ್ ಕುಮಾರ್ SR ತಲೆಯೆಡಿಕೆದಾರರು ಸರ್ಕಾರಕ್ಕೆ ಪಾವತಿಸಲು ಬಾಕಿ ಇರುವ ಸಾಲಾಯಿ ಬಾಕಿ ಅಸಲು ಮತ್ತು ಪಾವತಿಸುವುದು ಮಾತ್ರ ಪ್ರಸ್ತುತ ಜಾತಿಯ ಕೆಲಸ this is what is my request, that my amount is already there with you. It has not been forfeited, and then comes within the purview of the Samadana scheme. Is 4. Is 4. Apply for that. They did not do. And the Samadana scheme is not everlasting. It is not particular time. I think we will also now from one year also. This is allowed demand.
This has been continuously going on from how many years?
2019 onwards.
You have been making representation, there is an order being passed, and then
The government's problem is to you benefit to the defaulter. Whatever comes you recover, it's for that. Instead of going for it can never be. Finally, the government has forced on that one day. In this case, the difference is 49,500. The government says that has been forfeited. It's not forfeited.
that was a condition, that was a condition in that, was it not a condition that
If
it?
the law says so, even if the law,
Now, if the bid amount is not equivalent of this 1 month,
yes.
then what is the provision? The condition is that is to be forfeited, alva?
That is not done here. There was no loss. The government says that the next 3 options sustain the loss. I will not be able to get the benefit. The option is that much more than that. That's what is my entire thing. Now I can read.
Is what is that act? Which is that act?
The Karnataka Excise. Release of the right for lease. It's not daily, it's out of,
Correct. Which is that it comes under the Excise Act. Right of lease of land of. Yes. Lease of sale left liquor. It is not even regarding sale of arrack, ala? Adala. Sale of arrack? Please. It's not available in this book. But it. What was the amount he had paid? 52 lakhs, huh? 45. And what was asked to be remitted?
That's the only difference amount.
That's the only difference.
I said in the the lease was cancelled and now the government says that it is forfeited, so you are not entitled for the same without telling the loss sustained. That's why I'm reading you.
Yeah, got it. Did you find that rule? Really, no. Do you have the rule? Comment. Yes, yes.
The person removed never. The disposal of the rate of return of is confirmed. And within 15 days of the list of communication and power of accommodation, make an application to the sites. If its boundaries selected for obtaining all crops. The application is the deputy commissioner of the district that the disposal of the crop on the area is used. Within 15 days on the rate of institute conservation order, public security for an amount equal to 1 month's rent in the form of cash deposit or government security or other security, or in any other form of guarantee. Within 30 days, 50 days, for the rate of the use of the public security for an amount equal to another 1 month, letting the security equal to 2 months, in the form of cash deposit or government security or other security recognized by the government or eligible and given by the scheduled bank. Within 60 days from the date of the public security is an amount equal to 1 month's rent, making the security equal to 2 months in the form of cash deposit or government. Since this has not been done for the extent of 1 month's rent, the disposal was cancelled. Now failure to execute is a deal.
Yes.
Where the person in whose favor the disposal is confirmed fails to comply with the provisions of Rule 16 and fails to commit to security the manner stipulated in any of the law of these of Circle 1 of Rule 10. The time specified therein, the scope of the act will be cancelled by the government because it is the report to get government. Also, offender shall be deposited because the manner as the government should be valid. Provided that the service to the declared and the license are bonded, the commission proposal is not 82 under Rule 1 shall be a principal defaulter, which shall however be not entitled to the excess amount. Is very important. The excess amount realized from the but shall be liable for losses sustained by the state government. The Excise Commission should enter the law and be corporate. So my number 72 is clear that in the event of the auction, the government fetches more amount. I will not be entitled for the excess. On the other hand, if the amount of the auction fetches a lesser amount, then that's 100 rupees. I am liable to make it good. That is why the second out of which there should be more. This case, my report information is that the re-auction, there is nothing based on report by the court. But the re-auction has redisposal done as actually the lesser amount of land on the yes. So now what happened is that the he was admittedly he was a defaulter in the security.
So you sought for an extension for payment of that area.
I said that you are taking the amount for the amount. And let me absorb all life. As a result of this, the entire property of mine has been put into the name of the state. That is why I am doing this. The next one last minute. If I can read the order, you can see, we clarify the position. Yes. Page number 27. Yes. DMD ಮೊತ್ತವನ್ನು ಸರ್ಕಾರಕ್ಕೆ ಮುಟ್ಟುಕೊಡುವ ಹಾಕಿಕೊಂಡಿದ್ದಾರೆ. ತೊಗರಿ ಮೊತ್ತವನ್ನು ಜಮಾ ಮಾಡಿ ಆದ್ದರಿಂದ ನಿಮ್ಮ 100 ಸ್ವರೂಪಗಳಿಂದ 7 ಮೊತ್ತದಲ್ಲಿ 10 ರೂಪಾಯಿ 2 lakhs 45 ಸರ್ಕಾರಕ್ಕೆ 31 ಹಕ್ಕುಗಳಿಗೆ ಸಂಪೂರ್ಣ ಬಾಕಿ ಮೊತ್ತವನ್ನು ಸರ್ಕಾರಕ್ಕೆ ಪಾವತಿ ಮಾಡಿ ಬಡ್ಡಿ ಮನ್ನಾಕ್ಕೆ ಕೆಲಸವನ್ನು ಅರ್ಪಿಸಲಿದ್ದಾರೆ ಬಡ್ಡಿ ಮನ್ನಾ ಮಾಡಲು. So this amount they say that who deposit this amount, where this amount they get some who do not know. So there is no failure on the part of the licensee. Now it comes to the direction of this one report. In WP number 548040 of 2018, decided on 8th December 2018.
Yes, you made a submission regarding payment of that amount by taking some time. And that was allowed. And what happened pursuant? What happened pursuant to this? You have deposited. What happened pursuant to the order passed by this court? You have deposited that amount. What is your grievance now before this court? What is your grievance?
My properties are put on the state government staff. And then no arrears. If the scheme of the government is applied for me, as and when it was introduced.
Where is the scheme now?
ಅದು ಹಳೆ ಸ್ಕೀಮ್ ಅಂದ್ರೆ ಮುಗಿದೋದು. That was compliant with.
But in light of the order passed by this court, did you deposit that amount and that scheme was applied to you?
Section, there is no arrears. If they adjust that amount.
And that is, what they say.
They say the amount is not available for it. Because forfeiture cannot be done for the reason that there is no loss sustained. If they say that this extent, amount is forfeited. That is not there. So that amount is available for me to be adjusted in the scheme. As a result, now there is no.
Why do you say that there is no forfeiture?
There is no forfeiture order, it cannot be. Forfeit, that is not certain. The reaction.
According to you, there was no loss to.
But it does happen before the commencement of the business of the most of July or a particular year.
Yes, that is. See, they are seeking. Remove the. Yes.
All this three contract. Yes, depository need to 49,500.
Yes.
Now this EMD notes that the forfeiture and the provisions of the book itself. Otherwise, the scheme is there. 17. Losses are there. So much loss.
Deposits to be made. Before first.
The person who stated order to better the problem. Online tells other they deposited suppose 6 of rupee. But the coming of
So in light of this, he has to deposit on the date of such acceptance, make a deposit of an amount together with the earnest money deposited under sub rule 6 of rule 5 is equal to 1 month's rent of the shop or the group of shop, whichever he owns, for which his tender, offer or bid is provisionally accepted. Yes. 1.5 months. 1.5 months.
This one rule is 5-6 mechanisms.
Yes. Rule 5 and 6.
Rule 5 sub rule 6.
What does it say?
When they submit the tenders, every tender knows what it is by 6.
Yes.
Every tender shall be accompanied by a understanding deposit of an amount equal to 1.5 months shop a group of shops the previous year. That deposit that is made of the form of different transformation. So this first line deposit is made not selling a subsequent tender. 5-6.
If he does not deposit that amount, you have to.
Tender already being submitted.
Correct. Every tender shall be accompanied with an earnest money. It is not paid.
So there is no entry of the tender.
So that is the first. That is the first. That is the first criteria.
That is the first criteria. Yes, that criteria not over. That stage is over. Now,
So this stage, there is no dispute.
Even the words, I'm still coming to 13, because still 13 there is no rule 13.
Yes. So in rule 13. After this earnest money has been accompanied with the tender.
Then this tender is accepted. Now this tender is given a tender along with EMP. Tender notes was open, and then thereafter respond to the highest bidder. So tender has been
Accepted.
Now what's at 13? Just make a particular deposit.
So after the acceptance, there is a deposit. Rule 13. Apart from the earnest money which he deposits.
Earnest money is
Earnest money. Yes, understood.
the person I read
The person who's tender. This is again equivalent to rule 13. The first part is rule 13 only. This is again rule 13 only. Rule 13 and rule 5, subclause 6, rule 13(1) and rule 5(6) are one and the same. So there is no dispute regarding that. Come to 2.
The deposit as required in sub-rule 1.
Is not made.
The proposal acceptance is better. So at that stage, it's proposal acceptance.
So it would stand cancelled.
Shall stand there. Next money shall be documented. Feature is there. And every commission may accept properly the next highest tender offer a rate for the right of
One second. In the latter case, the disposal shall be at the risk of the defaulter, who shall not be entitled for any excess amount released but realized, but shall be liable for the losses sustained. So there should be a loss.
There should be, that is, should be liable for losses. It is separate. If something happens, then the loss, what happens is, if there is a bidder number 2, I give to the bidder number 2.
And if the bid is lesser than what?
That is the loss question. Now suppose there is no bidder or I am not able to complete the sale.
Even according to you, that is a loss now.
There is no, in this case, there has been no loss. I just want to explain. You want to correct the part of the loss to EMP. That is not so. That is what my endorsement says. Their consideration has happened. Now, conceptually, I just want to make it clear, the loss that they are referring to with the EMP is only not a subsequent adjustment that we are provided with the some other.
Yeah, just read once more section rule 13. Let him come. The person, you just read.
Then 9, 10, 11, and 12 share. Immediately on the day such acceptance is announced, make a deposit of an amount, which together with the earnest money deposited equal to and not constrained at the shop or block of shops. The area of the investment that offer the deposit and requirements of the loan is not. Shall be given. And the function of the
Yes.
This was over. This stage was over. Now, can we see the next day? This going to be
Confirmation.
Accepted provisionally tender offer. He shall submit to the Excise Commissioner. The records of the proceedings connected by him for confirmation.
Yes.
So the bidder tender offer exceeds the bidder tender amount obtained in the release site by more than 5%. We talked about needs to be executed.
Now come to rule,
16 is the order,
so up to 15, there is no dispute.
15 was that is not. Then what's 17?
Yes. With the person.
The person in whose favor the disposal of right of equal member purposes found shall within 15 days from the date of
So this is the second part now.
this is
Second part.
so it is already made a report.
So after confirmation, this is the procedure now which has to be followed.
Please.
Within 15 days from the date of communication of the order of confirmation, make an application together with a list of sites with its boundaries selected for locating the shop or shops for a license in respect of each shop or groups of shop. So he has to give a 15 days communication.
This is pertaining to the location and
Location, correct.
three members. 15 days from the date of disposal of the order, publish security for an amount equal to 1 month's rent in the form of cash deposit or government security or other security or guarantee to the schedule plan.
So for all purpose, either by cash or by bank guarantee. So this equal to 1 month's rent.
1 month's rent. Then again, notice there is one more second guarantee. Within 30 days from the date of receipt of confirmation order, publish security for an amount equal to another 1 month's rent, making the security equivalent to 2 months' rental in the form of cash deposit or government security or other securities recognized by the government and equal to guarantee the schedule plan. That's what guarantee. In 60 days from the date of receipt of confirmation order, publish for an amount equal to 1 more month's rent.
So there is 3 months.
3 months. 3 months.
3 months.
Once a gap,
So there is 3 months. 1 month, then the another month, then one more month.
Then 15 days, 30 days, 60 days.
So 15 days, 30 days, which gives in installments.
Installments. What happened in this case?
105 days.
It's totally around
105 days of permitting bank guarantee. Immediately 1 month rent in cash. So 4 months.
either it is 1 month cash, 1 month the rent in cash deposit or government securities, or it is all.
Open for him to do a cash also. How will you do that?
It is only with yes.
1 month.
Correct.
Again, after 30 days,
It's 2 months.
2 months. But then within another 60 days, he has to add 1 more month back.
So first 15 days, 1 month, next 30 days, 2 months, plus 30 days, 2 months, then 3 months for 60 days, within 60 days. So totally 105 days.
Now, when you see the next,
Now, what is now the violation? So you, according to you, is within 15 days, then next 30 is 15 days, including the other 15 days. Right. Within 15 days, within 30 days, within 60 days. So totally 60 days. Not so. So it's only 60 days.
So it's from the date of the government. So when is the next provided? The government building.
So there is a provision for the government in the interest of the revenue to give some reasonable time for furnishing this security.
On the problems of Salud 1, it's 16 right? The renting of excess construction. That issue doesn't for air for
Yes.
only lessons shall be entered to excel the rent of interment of interest. The lessons are 2, which could put it. 2018. Person in whose favor the disposal is confirmed, fails to comply with the problem of 160 and fails to furnish the security in the manner stated any of all or support 1 of 7. Shall be at the risk of the defaulter, who shall, however, be not entitled any excess amount realized from such, but shall be liable for the losses sustained by the state government. The excess commissioner shall be entitled to assess such cost, shall recover it as if it were areas of land.
So it would be, but shall be liable for the losses
He
sustained.
shall be liable.
Only if there is a loss,
He
he'll
shall
be.
be liable for the losses. So when it comes there, the author has decided, this provides funds for, scheme, so that we can recover.
Correct.
But when in most cases, where the applicants have applied only under Karnataka scheme 4, Karnataka scheme 5, and then unless money deposit was forfeited, the same shall be adjusted towards the losses sustained by the state government from the disposal of the right of retail plus, and any amount in excess shall not be paid.
So there is again a criteria of loss.
Of course, it is. The scheme actually provided, and say,
There is a scheme wherein the applicants have applied for the scheme and the earnest money deposit is forfeited. The same shall be adjusted towards the losses sustained by the government, state government, from redisposal of the right of retail vend of liquors. In the event you redispose that, then if there is a loss sustained.
Any other idea? How? In this case, what, there was no loss.
So there is no loss.
No, no, we were able to sell it for 1 lakh more. I think it's in the investment also for loss. So, they are, what they are actually liable to pay me is excise revenue, arrears. They were holding the loss that they were not able, they did not pay that amount. So there is an excess dues, there is no loss dues from them.
But this is all applicable only when there is a loss.
When there is a loss. So if there is a loss, we can adjust an EMD. We are saying there is no loss, I cannot adjust your EMD. There is some other arrears, excess arrears.
Can you take that arrears from this deposit?
I'm not taking it, he is saying take it. I am saying this EMD, there is no loss to the state government in respect of this transaction.
Then
I cannot adjust it under Kamsamadala. He has other dues in respect of this contract, not have the losses, the excess dues are there. That dues along with interest is, he has to pay us. We are saying that our endorsement is, if there is a loss, I can adjust the EMD. What we are saying is, the main, whatever excess arrears is there in respect of the other component, please adjust the EMD towards that. That is, I will come to, I will show the document. So when I just finish reading this, if any loss being processed, it shall be recovered, I think the total arrears of land recover. I think it was, shall be recovered. I think it was, what an arrears of land recovery. The amount already limited to your cost shall not be.
Yes.
So let's, skip, let see verse 19 for a moment. Adjustment of deposits.
Yes.
This is what the statute is not very normal. Deposits.
Yeah.
Unless forfeited, according to this rules, shall be adjusted towards the final monthly rents payable by the person whom the license are issued. So if there is a forfeiture, my lords, it cannot be adjusted towards any dues. That is what this rule says.
All deposit unless forfeited in accordance with this rule shall be adjusted towards the final monthly rents payable by the person to whom the licenses are issued. Yes, sir.
Now, so far as on 11/11/2003, his EMD was forfeited.
Then what happens to the deposit then?
No, in this case, what happened was, he failed to comply with regard to the guarantees that he was supposed to give. He failed to comply with 17 PCD.
He failed to comply.
He failed to comply.
That is 15 days, 30 days, and 60 days. All the three he did not
All the
comply.
three he did not comply. At that time, we were not holding those sites. So there is separate excess dues for that. On 11/11/2003, immediately the EMD has already been forfeited. Along with the statement of objections, section R1, there is a forfeiture order. It was already forfeited on 11/7/2003.
For the dues which you have
This is forfeiture of EMD.
EMD.
Because he
Yes.
One, that's the provision for forfeiture.
18(1), where a person in whose favor the disposal is confirmed fails to comply with the provisions. Correct, it shall be forfeited. So what was the initial amount which he had deposited? So what is that? That was the amount which he had. No, you forfeited that amount.
2003 plus forfeited.
Yes.
Now, this forfeiture laws and again penalty. They are not challenged for this forfeiture anyway. So they have accepted this forfeiture. Now, as far as these dues are concerned, anything. There's some
Yes. Page number?
Page 28. That's the table. This table just use the figure. Page 28.
Yes.
How much there is
Now, what you have done by this now? What is that you have done?
Excise areas for them with regard to rents that he had to pay. That is the bid that he had made was for Shimoga it was 92 lakhs per month. That is the rent he was supposed to pay. For Sagar Manoj it was 33 lakhs. And for Vasanagar Manoj it was 21 lakhs 33,000. So
It is around 3 crores 38 lakhs 10,000 for Shimoga.
Shimoga Manoj, this also what we are saying is actually excise arrears that he has to pay. It is not the EMD amount.
It's the rent.
It's the rent that he has to pay because he was in fact did business on the basis of this bid. And for the months till we actually cancelled his thing, he continued to do the business.
Yes,
For that there is rental arrears, the rent that he has to pay. That is for Shimoga and the Asalu is 4 lakhs 71 lakhs 95,000. Now, my lord, statute, there is also what is called the interest that he has to pay. The interest amount that he has to pay, as on 2017, so the 15% statutory interest is 9 crore 14 lakhs 32,532.
Total what?
Total minutes was as on that day 27 crores. Now, notice the customer scheme what excise is that if a person pays off the entire excess dues, that is the rentals, then I will waive the interest. That is what customer scheme is. Now, what he is saying is, out of 4,71,000 lakhs, you adjust my EMD first, then balance is 250. Below that, there is a bigger number. So, let's see the next paragraph. Not to get two figures. 2 crore 19 lakhs.
Yes.
Fourth line of next paragraph.
2 lakh 19.
2 crore 19 lakhs. And then there was the same sentence, there is 2 crore 50 lakhs.
Yes.
Now, what he's saying is, adjust this for the 4 crore 71 you adjust, I EMD of 2 crore 19. And I will pay to.
That is the EMD.
EMD.
EMD of 2 crore 19 lakh 49,500 to be adjusted to this 4 lakh 71,095 406.
Balance will be 52. That is what they are saying. And now he has deposited 252. According to us, he was supposed to deposit 471. What he is saying is he's trying to adjust that EMD towards rental amount, not losses. Losses, there is no losses. EMD is already forfeited.
So the question of adjustment would not arise accordingly. Then what is the remedy available for them? Where are you reading?
Page 14.
As
on 31/3/2017, his interest amount was 9 crores odd.
Correct.
In other words, is the amount is if suppose if deposits to he has deposited 252.
Correct. According to him, it is.
That if he deposits 290, that's what the endorsement says. Deposit 290. As on that day when I issued the endorsement, Karnataka scheme is there. That was 31/3/2024.
You will waive the interest.
That will be waived under the scheme. But when I issued the endorsement, scheme was there. Till 31/3/2024, Karnataka scheme is there.
That has to be applied.
That has to be applied. And if by 4 crores, if he deposits 290, entire amount is waived. What he is saying is, I will not deposit 298. My EMD is already forfeited. By misinterpreting the proviso saying that there is no loss, therefore EMD cannot be touched.
So your claim is in respect of the rent which is there.
Yes, I am not on losses. There is no. There are two provisions. What the Karnataka scheme can I just show it?
Karsamadana scheme is not produced before this court.
Page number 23.
Yes, sir.
That refers to.
Is there no provision to adjust the EMD?
No, there was losses. I practice the EMD.
Then what happens to that EMD then?
EMD actually stands forfeited because this court is saying that the right to there is no right of
Correct. There is no fundamental. No, now, see, there is a provision under Rule 17. It says under what conditions and what are the conditions to be fulfilled when he gives a application for license. Now it was accepted. There was 15 days, there was 30 days. Now this provision he has not complied. So according to you, you have forfeited that amount which he had already paid at the time of tender. Please cancel. So, but one thing, in Rule 18, there is a provision which said in the event, even if it is forfeited, money deposit was forfeited, in light of this Kara Samadhana scheme, the same shall be adjusted towards the losses sustained by the state government. Now, whether can it not be adjusted to the losses which now this is also a loss, right?
It's not a loss, this is actually what he has gained. This is the rent that he enjoyed the lease for that period. Plus losses. So now I re-auction it after a few months. Like till that time, they were able to enjoy the benefit of that.
Correct, understand.
So they have to pay the rent. No, that is not a
No,
loss.
when this provision can state that if the amount is forfeited, you can adjust it towards the losses of the government. Why can't you adjust it to the present EM? So that is the question this court is.
I answer that. First, the adjustment based on the statutory provision. If the statute does not provide for that, they cannot adjust it. Number one. Number two, what happens in this? Suppose, let us assume there was loss. I'll just give an example. In the statement that I showed, there would be excise rents due, that is 4 crores or there will be interest on that. Then there would be a separate column that because of this I had 2 crores loss. Or there is only 1 crore loss.
Yes.
But even if there is only 1 crore loss, what the proviso says is, if you expect 2 crores to 8 lakhs, it will be adjusted only for that 1 crore, balance will not be refunded to you.
Correct.
So, you cannot, here in this case, loss is 0. So therefore there is no question of adjustment. Because all I'm saying is the intent of the statute or the intent of the act was excise dues. Yes.
There is some amount which has been forfeited for one or the other reasons. That's
what it is. But the concept of unrest money deposit. With regard to lenders' costs and
correct. There is a forfeiture.
Yes. Regard to the fact that when unrest begins, then you have the unrestness to participate in this, and therefore I am depositing as an unrest. Now that amount is always subject to forfeiture under petition or tender conditions.
But then, in light of this clause, in light of this Kara Samadhana scheme which you have introduced, it gave a protection to the licensee holder to say that the forfeiture, in spite of a forfeiture, which is usually not available to them, it gave a provision to them that in light of this forfeiture as well, the losses which you have sustained, so you can recover from that. So that was an adjustment which was made. No, this is the proviso. That is what. So you gave a liberty to that forfeiture. You gave the liberty to that forfeiture. In fact, if no, correct. You give a liberty to the forfeiture. What happens in forfeiture is you take that amount as a whole. This, nothing is available to the holder. Now that you have given something to them.
Whether that can be extended for other things also, because still matters to what I'm saying.
23.
Plus, I just reading the notification.
What is this notification? This is Kara Samadhana. And why was it introduced? Why was it introduced, Kara Samadhana? Allah, why was it introduced?
Excess dues is what I am able to pay me as rentals or other bills. Apart from that, there is statutorily what is called the interest amount that accrues on a delayed payment. Now, because the entire idea of the scheme was that if you pay up the main dues, I will pay the interest because interest is statutory section.
What we requested you is already you're giving me a liberty of this Kara Samadhana by adjusting that to a loss which is already with you. That forfeiture amount is already with you, which this leaseholder or the licensee holder would not get at any point of time. And in that, the proviso says that the losses, if at all you take it and please adjust it to that forfeiture and don't claim it from me. Allah, that is how it said, right?
If there is any loss, apart from so far as the provider was concerned, provider left about just with the
Correct. Understandable, understandable.
It is referred to at page 20. Since the laws confer a provider to
There is a 15A. Oh. Yes.
Excess of the laws conferred the provider to hear the Karnataka excess, the condition of government DFS fiscal Karnataka waiver of interest in 4 and scheme itself is only waiver of interest. As okay in the government order so and so as an annexed to so and so, it extended to 2017. Can we see 15 number of them? This is general conditions of license.
15? General conditions.
Also maintain payment of waiver of interest.
Yes.
Salary 15.
Yes.
Payment of rent. The rent payable to the government, respect of the shop or shop shall be created by the license in the government where the shop is operated. Every month's rent shall be credited on or before the last of the year rent, which is 1 month to be at the rate of 50% per annum.
This amount claimed as arrears of rent or whatever. To what period? From what period to what period? 3 months.
Not a single day he has carried on. There is no question of that.
Not pay the rent, whether he carried on interest or not, loss is expected. If that is there, then we have to make.
So in light of this license being granted to him or the acceptance of the tender of his, You were giving him this premises on rental basis. Retail business, yes. Yes.
And this problem says,
Yes. So now in light, you want to say that in light of this Kara Samadhana, you have waived the interest.
they are going to get benefit. Because now.
See, there's a provision in the general conditions of license to waiver of interest.
Waiver of interest itself. And Samadhana scheme talks about waiver of interest.
So in light of this 15A, you have implemented this Kara Samadhana is your.
Samadhana scheme. Samadhana scheme 4 was enforced for a particular period. Thereafter, now this Samadhana scheme 5, which was enforced that period.
Same provisions, same.
But in that period, get paid off the rents, the dues, arrears, the principal amount. Entire arrears will get. What they are trying to do is they are litigating only on the aspect of whether my
Forfeiture.
like forfeiture should be adjusted to the rent. We are saying no, as per rules, it can only be adjusted. And against the loss, no loss, and I'm not adjusting that. What I said. That is the issue. Everyone wants. Interest is there.
He said he will give you the rent, he'll give you the rent. Please pay my interest in light of this Kara Samadhana.
There would be a rent, interest, plus in some cases there would be losses. So I said, okay, for losses, if your CFD is forfeited, I will connect it. That is what I said. That is the promise. What you are trying to say is, my EFD is forfeited, there is no loss. Please connect it with the principal amount and what was.
So that is not permissible according to.
Any exemption also, in terms of the statute. Otherwise, not, it has to be, it could be only in order of equity by this court. So far as this matters of concern cannot be done in the respect of submission. So these are commercial matters as well. And it's here for a moment.
15? Yes, you have read it now. Waiver of interest.
Yeah. Sir, it is continuous. The government pays.
So exercising this power, you have waived the interest in the Kara Samadhana.
Deposit that. He's doing this. Not deposit the entire amount.
He has deposited 2 crore for 19,000, 19 lakh.
No, 252.
252. So what remains is 2 lakh 92.
They have been litigating without depositing to like just to come to they have been and each of the higher.
If he deposits that amount, will you waive that interest to you?
There is no. Now there is only my.
No, but that Kara Samadhana scheme is not available.
My lord's president, since the matter was pending before this court. Because in the earlier two rounds also there was an order that it should not take disciplinary action. The attachment is there. There are laws as against this immovable property and the care of guarantee. There is an attachment. So what happens is the moment he deposits to 90, his attachment will be interest will be waived. Only thing is not my lord's scheme has an order. Facts. The extension of the scheme is already expired. In the fact of the matters of pending before. This is the third round of litigation that is going on.
Now the impugned order is at annexure A, wherein they said that you cannot adjust the forfeiture amount towards the terming it as a losses. That is annexure A. And annexure S is the Kara Samadhana scheme, which he says it should be applicable to the petitioners. Is it not? Yes. Annexure yes. Annexure B, sorry. And 5 is the annexure yes. Similar, alva? That is also similar. Same, similar, alva? Similar. So then it has to be extended now.
But what's the operating portion
Operative portion of the,
of at page 24 of the order? Review?
yes,
Because when is the date? 2024. This was before 31/3/24, when the scheme was still in force. And what's I just read. I'll just read the operating portion. This is what the writer said, but the leasing circular as well.
yes, let us ask the petitioner once. Yes, but now the forfeiture which is available under rule 18, it doesn't say towards the arrears which has been received, it doesn't say, it's only towards the losses. It is only towards the losses. Redisposal.
Successful bidder will comply with everything. 3 months she will carry on. 4th month he will commit default. Then they can adjust the EMD of.
Now, in this case, there is no initial stage itself is one, but then, as per the terms, you were given this for 3 months.
That is the bid amount, bank guarantee and 1 month security. Only entire difference is given to 1 month salary, which he has not carried on the business. As a result, the option was, he got more amount.
Now you have deposited how much amount you said? 2 crore, 52 lakhs, 45,906. Now what is the interest is 2,19,000, 2 crore 19 lakhs balance. That is the balance. And waiver of interest is available under the Karasamadhan.
This amount is deposited amount, which they have forfeited.
You say that you adjusted to that, that is not available in. That is the provision. Rule 18 says that there has to be a forfeiture, and the forfeiture can be adjusted if there is a loss sustained by the state government. Only on that circumstances it can be adjusted. Then
the rule 18 covers first stage and last stage. First stage is unmet money. Before that, you can take the option rule 4. It is not that everybody can go to the option hall. One should be a registered contractor. Someone look for the registered.
rule 4 of this lease of right, right?
Lease of right of. There is a section also declared about it. Now, my lords, under the rule 4, in the month of May, the auction conducting officer is the deputy commissioner of the district. The commissioner of excise will issue notification from the entire state, otherwise, whether fixing the date of auction. The person going to the auction hall will be a registered contractor under rule 4A. It is not that everybody can go to the auction hall. He must be a registered contractor, satisfy that he is a person of solvency.
Now, Mr. Bhatt, the question is whether the earnest money deposit which has been forfeited can be adjusted to the areas of recovery which has been claimed by the government, because rule 18 proviso says it is towards the losses sustained by the state. The forfeited amount can be adjusted only if there is a loss. There is no losses. So EMD. No, it cannot. The forfeited amount cannot be adjusted here in this matter. There is a forfeiture. You don't dispute. There is a forfeiture. If you say there is no forfeiture, then we have nothing to do. If there is no forfeiture, then there is nothing to be decided now in this, because
Okay, once it has been trashed, again it has another money. That amount is against the collects,
Only insofar as interest, if your client is ready, we will waive out that interest. We'll ask the state government to waive the interest. Not in respect of this. See the rule, now we have read all the rules, Mr. Batra. Yes, yes, 28 is with me.
It is flashed in it.
No, we are not looking this, we are not looking into this order. We are only seeing the amount which is available, not for any other purpose, not for any other purpose.
Amount available is not there.
Hey, that is, Mr. Batra, if you look at rule 18, the forfeiture which has been there under this rule can be adjusted only if there is a loss sustained by the state government for the redisposal in that circumstances only. That cannot be adjusted to the areas of rent or whatever has been claimed by the state government, because there is already.
Because one day has not came down.
But that was a condition. That was a condition. You were given on lease. You were given the premises. See, when you enter into a rent agreement, you don't enter the premises. That is the fault of whose? Allah, that is whose fault?
First July, I'm not there. I'm there on any.
Now, whether you are interested only in the interest portion, we will waive off the interest, saying that Kara Samadhana scheme is applicable to, and will.
The one is available. I can, I was to me, I cannot say online, no.
Listen, no, we have to only. Tomorrow only tomorrow. Tomorrow for further hearing. Morning, first start. I'll top of the list. Further hearing. Third, senior counsel, GS Bhatt for the petitioner. And GK Bhatt for the petitioner. Oh, is it? GK Bhatt for the petitioner. And AG. Yes. Ruben Jacob. AAG. Yes. For the respondent. This is. So think about it. Forfeiture is not available to you if it is against the arrears of rent. We are not here to decide whether you are in occupation or anything. You can do the best what is available to you in law to the petitions. Yes. Morning session, top of the list. List is matter, top of the list. Yes, next.
Ready?
You do same, huh? Who appears now for the state? Yeah. You're filing the objections. SCGP submits that he is filing a statement of objections. And the copy is been and would be filed in the registry by serving the copy on the other side, which is duly served today. Huh? When do you want? Wednesday. Wednesday.
Is this?
56. This is in respect of similar contentions? No. After the death. There is a contesting respondent is K. Manjunath. So license has been granted in favor of Manjunath. Savita died.
Yes,
Let him come. Let him come. Here no rules are, only rule 17. Only rule 17. husband of the first petitioner, who is Jai Shankar. Jai Shankar. Ah.
Holding the license.
Just a moment.
Here, two.
Yes. Ah.
Holding the license. He died on 9/2/1997.
9/2/97. That is not in dispute. Ah.
And
What is that you are challenging now? The granting of license?
transfer of the license, my husband's license.
In favor of?
Third person, without our knowledge, we have a fictitious relation. Another question is. Let me argue.
Mr. Constable. Yes. Now you are challenging the renewal of license which is issued in the favor of respondent number 4. Alva? Correct.
And you can see it in the order. It was made
When?
on 36/1997.
First order.
Yes, first order. Date of death is 9/2/1997. The order of transfer of license from Shankar to Savita.
Who is Savita?
Savita was in priority earlier. Now she has no this.
Jai Shankar to Savita.
Savita on 36/1997.
That was challenged by you?
30th of July. Important paper.
Yes, yes.
Because one peer-reviewed license, new.
That is the way, that is the most happening day for CL7.
On the 30th of June 1997, a person by name C.N. Papada, Deputy Commissioner of Excise, transferred.
Now, in a lighter way, this court has to deal with CL7 and CL9.
CL7 is another new.
Yes.
CL2 license was transferred in the name of a catch.
No, what happened after 36/97?
She has been continuously running.
So Savita was running.
Savita was running for several years. But when I did this order, connection.
You just narrate the facts and then go back to the order.
So order was, Savita transferred the license to Savita, and thereafter to the present Manjuna was questioned in the petition which was dishonored.
When was the first transfer from Savita to the respondent number 1? 4. When was it? First.
23/9/2006.
29/3.
23/9/2006. License was transferred to Manjuna on Savita.
Yes. So that was challenged by you.
The water verification is a connection.
CH-26.
In the very preliminary stage. Which are the court? It's the question of delay on me. And I was able to convince on the report that.
Page 26, huh?
With the earlier.
The order, where is the order? You challenged it. You challenged it in the year 2019.
2019. That's a deal, I'm talking about. Actually, a question of delay was raised.
Correct.
Convinced and convinced that the order. This of the report directed the inquiry by the Central Crime Branch Police Office, Bangalore City. May I connection G order of this one report?
One thing, transferring of the license from Jaishankar to Savita was not assailed. From Jaishankar to Savita as well.
Yes, both.
Even Savita. Savita as well as Manjunath. Both.
On having some delay on my part.
Correct.
The honorable report directed the inquiry by the Central Crime Branch Police. The order is section G, dated 26 to 2021. If you read the order, it is very important and this one for to develop the.
Yes.
It has been found during the course of argument that one created the transform of the hearing and the part of the report for holding the license to be admitted that they had Shivram Gola on 1998. Contended that application passed away on 1998. In order to substantiate the contention, the certificate and RHC has been produced. It appears that a few months after the death of the Jaishankar, the government document was created showing that on 22/6/1997, the Jaishankar made an application agreeing to transfer the license in favor of 50 students. There are several other contentions posed by the Learned Council for the Petitioners to buttress this argument that all the subsequent documents are all documents. One such submission is the statement of objection filed by the respondent state. It is contended that additional license fee was also collected along with the fee of transfer. The Learned Council has pointed out the also then nominal and follow. Further, since it was contemplated, it was last time. Further, since it was the act of the if not, the person has claimed by the police officer can also find it out as to who the actual licensee was. If it is from that, the actual licensee is different person. We should also the inquiry should be conducted. The report in this regard shall be filed by the police officer nominated by the Commissioner of Police as expeditiously as possible. And at any rate, within a period of 2 months, it was complied with. The CCB police made a complete investigation and a paper was written. Report has been made.
What is the report?
Report has been submitted holding the guilty. Report is connection at university. I am not know the report.
Page?
Page number 54, annex H. Dated 15/4/2021. A report has been submitted. What happened is that source of COVID pandemic.
Yes.
Police, perhaps, by some mistake in the there was a receiving offer beyond the building. They have submitted the report in the receiving counter, rocket level. But however, it has been made over to the registry thereafter. And after seeing the report, the honorable judge, this on the report, made an order on the 7th September 2020. Declared order. allowing the request. Now operating person is 104.
Annexure J.
Yes. The repetition is allowed. The transfer of license dated 26/10 shall be subject to further inquiry by the Department of Excise based upon the report of the Assistant Commissioner of Police. Commissioner of Police is further action also on conclusion by the so the system 26 corporation is yes. How much record was that?
God vitiates everything. That is how.
This was relatedly questioned in the interview before this Workman. The Honorable Division Bank from the finally my lord turned down that I claim only on the ground of delay. The reason for considering the delay by the Honorable Division is the petitioners had made a claim of motor accident claim before the tribunal due to the death of the patient and that we have the knowledge of this case because in that some evidence is that not excise revenue.
But now the writ appeal has already been dismissed. Are they allowed and
Not committing for the Honorable Division Bench. The interview was time barred. The Honorable Division Bench did not consider the application for toleration of delay at all. Without answering the delay question, I have no confidence to
yes.
without answering the question of delay, the Honorable Division Bench allowed the writ appeal and set aside the order. But I did not question this division bench order before the Honorable Division Court for the reason that it gave me the benefit. Now, my lords, kindly permit me to read page number 133, page carrier number 29. Having thus found, it is clarified that the authorities who at 1955, the rules thereafter, would be entitled to initiate any inquiry with regard to the violation of provisions contained thereof, in respect of the transfer of license. This order would also not foreclose the legal remedy or option, if any, available to the petitioners before the competent court of law, forum, or authority, around the time is to underline this, forum or authority. And the petitioners are required to seek the permission of the law. The observations and given this claim in this order is only with regard to the stated picture or and all conventions is available. So the Honorable Division may go without the order. Give me the liberty to pursue my remedy elsewhere. Accordingly, I went before the Excise Commission, invoking Section 3 of the Karnataka Excise Act, 1965, and on 7/10/2023, I submitted a petition, original petition.
You went before the Excise Commissioner.
Commissioner submitted a detailed original petition, invoking Section 3
Section 3.
of the Karnataka Excise Act, which says that he is the chief controlling authority.
Yes.
And requested for an inquiry, investigation, and the prosecution, because the CCB report is there.
Yes.
Before I forget, my humble submission is that a lot of women. The report, the Honorable Division Bench did not even see the report, though it was available on record. I also please direct us, HT, to place the report also for the purpose.
So that report was perused by this court.
Yes.
So there is already an order. There is already an order wherein it says on the report.
Division Bench did not speak to it. I was speaking.
We are leaving apart the order of the writ appeal. Now we cannot look into the order of the writ appeal court.
No,
We cannot go beyond what is there in the writ appeal. And you have not challenged the order of the writ appeal. So we have to leave it as it is, And then you have gone to the excise commissioner by filing a petition. 10th of October.
Page number 141 to 145.
140?
145.
Yes.
Complete narration of that.
So you narrated everything before the.
In addition,
What did the excise commissioner do?
in addition, the excise commissioner filed an application on the report. And the repetition was pending. And obtained a copy of the CCTV. It's available.
So there it is available. He had an opportunity to look into the report.
This application of mine has not been considered critical. I have not received any notice of inquiry on this application before the excise commission. When the matter should pass, a representation has also been given to the deputy commissioner of excise, who is the transferring license surveyor for.
Yes.
Which at time I gave a representation of 6/10/2020. Giving detail of representation. Plainly, without considering any of them, the deputy commissioner, with the full knowledge that an original petition is filed before the excise commissioner passes an order, the operative portion is page number 155. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸುವ ಅಂಶಗಳ ಆಧಾರದ ಮೇಲೆ ಶ್ರೀ ಕೆ ಮಂಜುನಾಥ್ CH-27 ಸವಿತಾ ವೈಸ್ ನಂಬರ್ 203 ಅರೇಬಿಕ್ ಕಾಲೇಜ್ ನಲ್ಲಿ ವೆಂಕಟೇಶ್ವರ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಅವಕಾಶ ಆಯ್ತು 2023-24 ಸಾಲಿನಲ್ಲಿ ನೀವು ಸಮೀಕರಿಸಿ.
Yes.
Again, my lord, because question is a petition because difficulties can also face. The other again, my lord, directed the honorable judge page number 166. Yes, the second petition. The petition is around in March. The third respondent's order dated 28/11/2023. That renewal of the license is restoring the third respondent, the deputy magistrate, the petitioner and the fourth respondent, without further notice, appear before the third respondent, the state court will be. The third respondent can decide on question of meaning was strictly in accordance with law. Now what happened was proceedings were done. And again, page number 184, order. We have an option of doing particular ತಿರಸ್ಕರಿಸಿದೆ. ಹಾಗೂ ಇದೇ ಮೊನ್ನೆ ನಾವು ಪರಿಚಯಿಸಿದರು ಪೂಜೆ ರೀತಿ ಅನೇಕ ಕಾಲದಲ್ಲಿ ವೆಂಕಟೇಶ್ವರ ಬೆಂಗಳೂರಿನಲ್ಲಿ ಒಂದು CH-27 ಕರ್ನಾಟಕ ಸಮೀಕರಿಸಲಾಗಿದೆ. First one says, subject to the outcome of the proceeding pending before the excise commission. Here it does not say so, does not refer to the excise commission. And my license that will deny. That was the time issue. The question of delay was there before the honorable signature is not going to go. It has been explained, accepted. So, it is issue, I could not question if the honorable signature. The delay question goes at the level of the preliminary stage. Once the honorable court decides the petition on its merit, that it may not merge into the main. However, as unfortunately that is decided. When the matter is
Now, as on today, we have to assume that there is no It is not held that there is a fraud. Though there is a report, though there is a report, though challenged before this court, the petitioner was unsuccessful in establishing that there is a fraud played by the respondent. Correct. Because that has been, writ appeal has been, correct, but there is no right been conferred upon you. There is no right. Now you have filed a petition seeking for the initiation of any fraud that has been played by the. Now it is not done till now. Is there, did you file any petition to seek for a mandamus to consider that petition? To seek for a mandamus for that consideration? Now in this, you are against the order of granting license in favor of respondent number 4.
I think everyone. That's what I think
Till now, there is no consideration of that. So anything would be like giving a license to a person which has been already been given already.
The Deputy Commissioner of Excise, when this liquidation is pending, permits the shifting also to another place,
Another premises.
and after one more information I have received is that the transfer of the license has taken place.
See, Mr. Batra, see, this Jaishankar died in the year 1997. Okay. This Jaishankar, according to them, had transferred it to Savita in the year 1997. That is 36/1997. And then this Savita was. No, but then, what was done by you during that time? What was done by you? What was done by you?
They are not aware of it.
No, when there was a license in favor of their father.
Normally, this liquor business is every. ಎಷ್ಟು ದೂರ ತರ್ತಾನೆ ಏನ್ ಮಾಡ್ತಾನೆ
There is some
enforcement. I inquired everything about that. He was totally ignorant of this. Her health condition was so bad. The police will say sometimes she came to her office also. It's not. No, she has to give 2 chances for her to see. That is the solution. So all that I explained the delay. That is the CCTV report. It may not be.
Now that delay, now everything has been subsided in the writ appeal. So as of now, there is no order of fraud or anything on record now, other than the record. That is by the Excise.
One FIR is registered based on the CCTV report.
No, now it is for the Excise Commissioner.
I think it's not the one. What things is mentioned correct, there may not be much. What can be heard by the commissioner? Others can be very within it.
Oh.
Because they are mainly running the business. And very top ranking.
So now till the consideration of that application.
The detailed representation I have done.
Yes. Yes, state what you say. What happened to that petition which is. No, division bench said, remedy is available to you to go and approach the appropriate authority by filing a petition. Now he has filed a petition. Now the Excise Commissioner.
The Commissioner of Excise, when the statement says he doesn't have a power to inquire into all this. That is what also.
Having come to para 29. This order would also not foreclose the remedy.
That is what the problem is. The entire starts from page number. Senior counsel continue tomorrow, but kindly.
No, if senior counsel wants to address, let him address the argument. Let the senior counsel address. And what the state has to do is, what happened to the petition which has been filed there? What is the progress in that petition? To whom did you issue notice? To whom did you issue notice? To the petitioners. And it was written answered. 28/11/2023. That is the subsequent order. That has been ordered, and this court passed an order allowing their writ petition and remanded the matter for restoration. And that would be subject to the consideration of that. This was restoring to the deputy commissioner. Yes. Now, what is that writ appeal order? Which what observation you said?
Paragraph number 20. Page number 25. First paragraph.
Yes.
The issue of fraud and fabrication of records documents is complex aspect. Thus, even I'm taking note by running single facts, but disputed questions of fact not the one implementation. Now, can we come to next?
Correct. That is why they were asked to go before the appropriate authority.
Paragraph number 17. Senior counsels will keep up appearance for the writ petitioner as well as the task to learn and additional government advocate. No provisions under the Act or whatever would be justifying inquiry by the Commissioner of Excise, Department of Excise, Commissioner of Excise or Department of Excise, complexity of the nature of the mounted above. Though learned senior counsel, learned additional government advocate, they are not inclined to accept the same, as the said provision do not cover the matter of this nature to be investigated by the authorities under the Act of 1965. The said provisions are extracted. Now, when we come to para 18.
Now, see, there is a petition now filed before the Excise Commissioner.
Yes.
Let the Excise Commissioner pass any order saying that it is not maintainable at least.
He cannot, that's what the
He cannot say that it is not maintainable.
yes, this honorable court said he cannot inquire into or go into. When is paragraph number 18?
Then, if something is filed before an authority,
Yeah.
the authority has to pass an order saying that it is not. Let them know where they have to go.
Which provision? Section 3 is a more of the commission of
We can pass an endorsement. That is for the state to answer. That is for the state to answer. Come to para 29 now. After giving all this observation, it is held that
what it says is, having thus found it is clarified that the authorities under the Act maintain under the system to initiate the inquiry for violation.
so any inquiry.
Excise authority, but like some other authority.
Yes.
Alternatively, even they are entitled to initiate the proceedings, that is exactly the proceedings which earlier they failed to initiate. That is not into the excise authorities, but some other authorities. I may not suggest to which level. When we see, that is why I said it is not because when we come to observations we did paragraph number 18 of the revision bench. It's paragraph number 18, page number 127. Thus, the permission of the associate provision make it clear that there is no other provision to enable the authorities to take inquiry, investigation, particular aspect of fraud and prosecution of and identity of offense. The investigation and inquiry contemplated under 5 are in respect of offense under 622 of the Excise Act. And chapter 8 of the Act, the senior counsel to ensure fairness of it, that inquiry investigation into the nature of the matter. All the present things can be undertaken upon file a complaint more to its domains. There is no bound about the fact that the Excise Act 1965 or Rule 1967 does not contemplate any provision to the situation. And having said so, Can you go and submit the same authority study? No, kindly come, this is not a small, kindly come to paragraph 20. Paragraph 20. Include the opposite position of law, enunciated by the apex court, and also in items of also in the Excise Act, because of the incident deemed. The include of that, the additional excise department to conduct an inquiry, and on the basis of the report by the Assistant Commissioner of Police, the works of already from the part in the restriction cannot be sustained as such the inquiry department no police. Police. What was it? Now they want to explain the same color, which level signatures have given. Now, kindly come to 120, 132 laws. 131 Excise.
We're going to complete the argument. This matter tomorrow. Monday for further hearing. Further hearing. GK Bhatt for the learned senior counsel for the petitioner is heard in part. Is heard to hear the respondent counsel. Is this matter for further hearing? Yes. Monday. Very good. Yes, pass up.
My lords, I appear for the petitioner in this matter.
Yes. Yes, Mr. Hegde, you have accepted annexure R1, but it is 34, that is the measurement. You did not mention about, the corridor area there. So then you have to, yes. So now the compensation only to the extent of compensation. See, the trees were coconut trees, 49,000 plus this, what is that? Husk value 5,000. Adding, we get deducting the 30%, you get 37,700. One neem tree 90,000, right? The jali tree 5,000. Then teak wood, teak trees 90,000. Then which one more tree is there?
Bunny tree.
Tree is 5,000. You have been given 2,70,841.25. Already paid amount is 1,20,154. And you'll be entitled for 1,50,687. Serial number 1, no? So that is not in dispute. Then areas 36. Why? You have admitted annexure R1 in your come to this order passed by the
Para 13, my lords.
Para 13. The petitioner has stated that nearly 4 acres of land has been utilized for drawing the electric line, but there is no proof of that. On the other hand, the document produced by the respondent at annexure R1 discloses that an area occupied is 36.57 guntas for drawing the. Yes, you have the annexure R1. Good. Annexure.
28.69.
You have annexure R1.
record was found before the dishonorable court. I have taken the extract of that in the court minor. Not only mine.
When did you take this extract?
It was, the record was there in 2014 or 15. Thereafter, it was dismissed for non-prosecution for about 3 years. It was not recalled. After that, record was made. It is undisputed that it is 128 was the inclusion of the corridor area.
Yes, Mr. Shirish Krishna.
Yes, my lord.
Appears that as per exhibit R1, the extent of contact shown is 128.49.
Correct, my lord. The heading there is excluding corridor.
Where in annexure R1?
Annexure R1, my lords, where
You have
120.
the annexure R1. You have the annexure R1.
I have annexure R1.
Just read that annexure R1.
Annexure R1, it says excluding corridor, it says under the heading. There are
Including
two.
corridor is 36.57.
Exactly.
Including corridor is 120. 128.
128.49. What they say is you have admitted that the occupied area is only 36.57. Correct. You are not entitled for this corridor area. What is that corridor? What is that corridor area?
I'll explain, my lords. When we draw the lines, the lines under which the area comes, that is the.
Yes. That is the corridor area. Huh?
That is the line area.
Then what is the corridor area?
Corridor area is the just like we have two space where we have to leave vacant.
How much? To what extent you have to leave vacant after the line is drawn?
66 area. It's about 18 meters. 9 meters each side.
Yes, where is the notification for that?
The guideline also is there. Last time I didn't have a guideline where
You last time ಕೊಟ್ಟು next time ಬರಲ್ಲ ಅಂದ್ರೆ ನಾವ್ ಏನ್ ಮಾಡ್ಬೇಕು Mr. Spurti Hegde? This is what causes so much inconvenience to this court. Yes. Where do you say 66 kilowatt? The state duties may adopt these guidelines in their entirety or usually they will modify. Where is that? Corridor area ಅಂತ ಹೇಳಿ ಹೇಳ್ತಾರೆ.
first column connector 1 minus 8
This annexure one. Compensation shall be payable only for transmission line supported by tower base of 66 kV. Then where is it? Notification ಕೊಟ್ಟಿದ್ದಾರೆ. Where is that? When did you give this notification?
22. Nearby.
Yes, where do you
Next
go?
step 1 minute.
Huh.
Next step 1 minute. Heading. Right of way for the normal road, forest area, urban area, population area, and appropriate sector near. And the last.
Yes.
Last column. Road width in meters. For compensation purpose. But in the next page, 66 kilowatts is given at the last one. Page number 3. 66, 18 meters. 18 is there. So 18 meters width, we have, it's a corridor area. Here they have taken line area as 36.
Line area is 57.
And corridor area is 20.
Yes.
So corridor area has to be included.
This is 18. This is shown as 18 in 66 kV.
66 kV line is gone. This
Huh. Then how do you say it is 128? Court is asking you, how do you say it is 128?
The land occupied on both the sides.
Yes, how much? 18 meters. 18.
It is 9 meters on each side.
So then 18.
It comes to 18 meters. Like the entire extent of the line area, 128 point something meters was being acquired.
Where is that material to show that? Where is the material to show that? Where is the material to show that the corridor area is 128.49? Where is R1, Mr. Constable? R1 is this is your notes. Where is R1? This document, what you are producing to the court.
My notes. Yes, in the record it was there, madam. So
I'm sorry, I was logged out. I'm sorry, I was logged out.
Let the records come.
Yes, yes, ma'am.
Call for the records.
Grateful, ma'am.
Ah, 230. Okay. No. Yes, yes.
I'll not take the 20 minutes but already on the form.
Yes, this matter in the preliminary hearing. 36. On Wednesday.
Your Lordships, bill number 30, Your Lordships, may I kindly
Let that time. Prelim, just a moment. Yes, we will take up your matter. Well, would you have made notes? You have made notes to that text. Everything is proper. We will not waste 1 minute time in that. Yes. Then rest all matters whenever, whichever date you all want, you all take. Yes, which is it? 22? 22, 19. 19, 19. 19, 19. Yes, 19, 19. Serial number? 23 tomorrow. Not tomorrow. Tomorrow we have second appeals. 11th. All matters at 2:30 difficult for this court. At 2:30.
Number 24.
No appearance. This matter? Week after next. No appearance. Don't say no appearance. It's already for you.
85.
This week after next.
86. This is the
18.
27.
18.
30.
My Lords, on 11th, my Lords. I request for 11th, my Lords.
11.
Grateful, my Lords.
Tomorrow. Nale list already. Wednesday. Next Wednesday. Yes, Mr. Shankar Reddy. Adu 18 alla.
35. Pending order.
19, 18.
57. Ravi Raghavan.
11. Yes, 11.
38, Kiran is not up.
Devraju. In a preliminary hearing. This is matter in preliminary hearing on 11.
39, should be here.
Interim order. Interim order granted earlier is extended. Late. I mean interim order.
41.
18. 18.
43.
18. When it counsel for the petitioner submits that due to inadvertence, the interim order granted earlier was not extended on the last occasion. The submission is recorded. Interim order granted earlier is extended till the next date of hearing. List this matter on. Yes.
44. Ravirama.
Similar. Nandakishore has filed his objections. He has filed a statement of objections. So pleadings are complete. When do you want 11? 11. What is that? We will see. You mention it on the next date. Mention it on the next.
45.
49, 45. Yes, madam. That burnt up. What have you done now? Have you given them money alternative? So we'll dispose of directing you to produce the documents. So according to you, do you say that their shop is not burnt? Do you say that it is not burnt at all? See, when the fact is, correct, this was allotted to them, that burnt shop was allotted to them. So according to you, in the petition also and before you, there are no records to show this shop was allotted to the petitioner, the burnt shop. What is burnt? Which is the shop burnt? 50, 70. And according to them, 70 was allotted to them. And according to you, 50 was allotted. And you have records to show. What you say? It was 50. To show that it was converted to 70. Take this matter in preliminary hearing. Yes. On 11th, Monday. Wednesday. Preliminary hearing. See, if at all there is an agreement saying that it is survey number 50 is. We will see. You file it in the counter. You file it in the counter. It will be an acknowledgement to you. Yes. So what should we do now? No, what do you want this court to do? This court is sitting idly from 10:30 to 5:30. Is it so? Is it that your submission? Is that your submission, Mr. Counsel? Then this is a matter of 2022. When did you move this matter for the first time? Then when was it listed? Earlier date, Nodi, when was it listed? It was listed on 25/7/2024. After that, the matter is not listed before this court at least. Then where did you say it has been listed 10 times? Where was it? Where does the order sheet depict? Where does the order sheet depict? Kindly look into the order sheet. See, you should not make anything which is not on record. Go and give him the order sheet. It speaks upon the court. Just look into the records. No, look into the records. Does it say it was listed anytime after 25/7/2024? What was the last date when the matter was listed? Was it listed, Mr. Consul? Do you know how to read an order sheet? 22/7 was the last order when the matter was listed. After that, was it listed before this court or any other court? Where is that listing of the order sheet? Does it really reveal? Does it reveal? How can you make a submission that it was listed for 10 times? What a submission, Mr. Consul. Huh? Somewhere in the year 2022, it was listed. At least not before this court. This court, for the first time, it is listed. Yes, what do you want? List this matter after 2 weeks.
P3. That is Suri.
When do you want? CL7, CL9, what is it? CL7. Excise matter, right? When do you want? 11th. 11th. 11th at 2:30.
P4.
Abdullah. Hopefully next week. Yes.
55.
Yes, Mr. Mariappa. 11. 11. Yes, Bunny.
Serial number 1 password matter.
Yes. I asked your colleague, why the urgency, Allah? You should move the trial court itself.
Taking the expiry of our protection, that we cannot compound one. If already a constitution is there, after then they have filed a suit for.
You're Mr. Sudhakar. Mr. Sudhakar. This is a suit for declaration and injunction filed by the plaintiff. Plaintiff has filed an application, I number 1, seeking for an ex parte order. An ex parte order is granted. IA1 of 24 is not yet disposed of. So, how is this petition before this court maintainable in light of an order not? We understood the facts.
There is no reason to bring the telephone for the planning company. The court has not said anything, sir. Then appeal becomes a meeting. This is a 20, the expiry order.
Yes.
The plaintiffs have filed IA number 139.
What are you reading? What are you reading?
The order sheet.
Order sheet.
Page number 20.
Page number?
Plaintiff have filed IA number 139 of Mississippi, February intention to restrain the defendant and analysis. IA number 39 C on account of temporary intention to restrain the defendant and The reason of the plaintiff, as per the plaintiff, the order of the plaintiff is not yet the property when the Mr. Secretary dated 460. And after that, and my father of the plaintiff, then the plaintiff has succeeded to receive and became absolute owner. At this stage, the reason of the documents, plaintiff and I case, if the notice is not a regular object of regulars, hence I was out of was college. Really consideration of the issue part of interface time no business is right. Nobody is saying that they were not the owners of the property. Intent claim is not. We have executed the same thing in favor of the defendant 1 to 4 along with the defendant 5. And defendant.
Who has executed? The plaintiff.
Have executed a same thing. There is a delivery of the registered sale.
Then you have filed your objections before the.
Since dependent number 5 is not served, the matter is posted on 30. Meanwhile, taking the not interfere in that, you may not. Can you get the photograph?
Yes.
The first photograph is the state of conception where I am looking. This is the state of conception. Now, the order of intention is issued not to interfere with the peaceful possession. In half of the portion of property, DPP has already found a Workman, 100 feet road. It is being surrendered to DPP. Remaining extension is kindly see the page number 3, the photograph. See the compound was demolished in the overnight after taking the DPP model. My threat is my building is also going to be demolished.
Yeah, you understand the difficulty of this court also. See, the IA which is filed by the plaintiff is seeking for a temporary injunction. You're the defendant. You're the defendant. You're now seeking for an injunction order.
No,
Latin, not to alienate, of course. Now the question is, you are the defendant, you are seeking for an order which would overrule the ex parte order which is already there.
There is a registered document of it. This itself is not being done. The entire case is
correct. That you can do it by giving your objections. You can give all the contentions. So we will say, without considering whether the notice has been served upon dependent number 5 or not, the trial court to consider the application I number 1 of 2024, 1 and 2 at on so and so date.
They are already demolished the neighboring number. Now, if they demolish overnight,
Yes. Who appears for the plaintiff here? Who appears for the plaintiff? Then somebody has filed caveat. No, somebody has filed caveat.
Yes.
No? You are appearing for?
They are not the plaintiff. They are the defendants in the bill. Yeah, that's something. There is a registered sale, delivery of possession by the plaintiff. There is an internal understanding between the plaintiff and the defendant wife. And the police complaint is given, they have received a posted check to the defendant wife. My sales
See, the law is well settled. When and without taking any recourse to order 39 rule 4 CPC for seeking for setting aside the ex parte order. But then what is that you're seeking? Your Mr. Counsel, how can such an application or how can the submission of yours be considered? You must be you are aware about all the laws. How are you making a submission to this court? Then it is for you to approach the trial court, no? Not in this. No, we should not. Oh, yes, you give the judgment. Tell me where it says that you have to override that ex parte order and come to this court. Come to para number 6 of the first judgment. with regard to the maintainability of the appeal against an ex parte order. So against this, there is an ex parte order without asking recourse of order 39 rule 4 CPC seeking discharge of an ex parte order of injunction. He submitted that an appeal under order 43 rule 1 R CPC is not maintainable. So you have approached this court without seeking for the discharge of those ex parte where the trial court does not regard reasons. Where is that? Where does it quote say? No, para 6 where the trial court does not record reasons for its opinion to grant an order of injunction without giving notice of such application to the other party as required under Rule 3. He placed reliance on para 13 of the judgment of the Honorable Supreme Court in support of his contentions. So, Shivaramas. No, this is not in that contest. You have to file an application for discharge.
There is no reason to decide with the trial court. Nobody's case that we are not owner. It is the case of.
You are seeking for an order, which there is an already an order of ex parte order which is there in favor of the plaintiff, and you are the defendant. You are seeking for an injunction order again, which would always go contrary to each other. That you have to go before the court itself. Absolutely no reasons ಅಂತ ಹೇಳಿಕ್ ಬರಲ್ಲ. There is some reasons which is there. Now, why don't you go before that court?
Is demanded in a 10 days. Neighboring what's of the order they are going to demolish my building.
This is all available to you before the trial court.
In 10 days, another 30 days. If the defendant is not even served before the court.
So we will tell the trial court without waiting tomorrow. You please direct the trial court to list the matter tomorrow itself or on Monday and do that action.
Overnight, the building is demolished. By virtue of the order, the building is going to be demolished.
We are with
They are
you.
taking course of the.
We are with you. When was the ex parte order passed?
14.
And where are we today? It's clear.
There are 15% security. We have secured the property, manner. We have secured the camera. It is a lot of big manner. I produce a photograph where the.
We are with you. We cannot go against what is there on law. We cannot go what is there against.
There should be a restraint in the printed.
So Sudhakar, should this court tell you you're a seasoned lawyer, Alva? You're a seasoned, you know.
What's of the court order they are going to demolish my property. Not maintainable.
No, that is all available to you before the trial court, not in this matter. Why did this matter come before this court now? Why did this matter come before this court? Why did it come before this court? For what reason?
Because I have sued. I do not know the reason to court.
Yes.
Maybe I have sued. In some other case, in a similar ex parte order, court granted, same where I appear, court granted, so far as not people here in person is concerned, that order was stayed. A similar order may be passed. I'm not seeking total vacation.
You know the restraints of this court. What do you have done? You will always appear for the respondent sometimes.
This is open. I bring the document. They want it for property is sold. Several sites is sold. Immediately says it is executed. There was the same kind of similar threat, my lord. There was a protection. Mandali Rangana case says when there will be construction is going on, subject to result of the case, the construction can go on.
Philip?
There is the construction is already started.
Mandali, the first matter. No, no.
Number 28.
You know, what is your ground made out? You have purchased the no, present facts. What is the present facts?
Case of the painting is that painting is independent. There is a part consideration paid to the painting, part consideration paid to the dependent on the file. And in turn, dependent file, in their own arrangement, they have taken posted checks for the dependent file. They realized that posted check part payment. Thereafter, they did not realize the part payment.
What is your right now in this property? What is your right in this property?
I purchased the after issuing the public notice.
From the plaintiff.
Plaintiff has sold it to dependent 1 to 4. Dependent 1 to 4 in that they have sold the two properties. Sale deed is executed in 2017. We have purchased the property in 2024. After issuing public notice, everything, after full scrutiny of it, there is a waiver is found. Now they have filed a stay saying that it's not happened in 1883. The dependent 1 to 5.
Who is 5? Who is 5?
5 is being governed as a confirming party.
With the plaintiff.
The plaintiff. They had an understanding, they said, you pay the part consideration to them, past consideration to them. Thereafter, the police complaint is also large secretary dependent on the file, saying that they gave a posted check that is not valid.
Now, which is the plot you have purchased? What is the plot number you have purchased?
Plot number 5 and 6.
5 and 6.
Both are constructions.
Yes.
2017 is the same date, 2024 is
2017. Sold by dependent number 1 to 4. When did the plaintiff sell to dependent number 1 to 4?
2017.
2017. And you purchased when? When did you purchase?
23. On 13/9/2023.
You have entered caveat. Respondent who has filed colored for respondent. No deposit cost is correct. Respondent number 4, 5 to 7 have entered appearance. Issue emergent notice to the other respondents. Learned counsel appearing for the appellant would vehemently contend that appellants 1 and 2 have purchased 1 to 4 and 1 and 2 and appellants have purchased a plot number 5 and 6 from dependent number 1 to 4. The plot number 5 and 6 in survey number 113. 113 from dependent number 1 to 4 who have formed a residential layout after purchasing 2 acres in survey number 49/6 old from the plaintiff in the year old for 49/6 new 113 from the plaintiff by the registered sale deed dated 19/8/2017. Learned counsel vehemently contends that the plaintiff in collusion with defendant number 5 has filed the present suit seeking for declaration and injunction injunction contending that the plaintiff is in possession of the suit property, survey number 113, old survey number 49 bar 6. Bar 6. Bar 6. White registered, say deed dated 4/6/1981, and contended that pursuant to the sale deed, the plaintiffs are in possession of the suit property as an absolute owner. Learned counsel submits that the plaintiff has not brought to the notice of the court that the plaintiff has executed a registered declaration of the and stop. Not bought by the learned counsel for the plaintiff submits that the plaintiff appellant submits that the plaintiffs are not in possession of the suit schedule property, as they had executed a registered sale deed by delivering possession to defendant number 1 to 4 way back in the year 2017, and now in the year 2024. The plaintiff is seeking for a declaration that the sale deed executed in favor of defendant number 1 to 4 dated 19/8/2017 is not binding, is to be cancelled, and the trial court on an application filed by the plaintiff has granted ex parte injunction order not to disturb the possession of the plaintiff and not to alienate. The grievance of the appellant is that in light of the order passed by the trial court, the plaintiff is trying to dispossess the appellants and trying to demolish and also demolish the compound wall. And trying to demolish the construction put up by the appellants in the suit schedule property to indicate that the appellant have put up construction in the suit schedule property. The appellant produces the photographs annexed along with the memo. Stop. Having produced the material on record, though an ex parte interim order has been granted to the plaintiff and a protection needs to be accorded to the appellant's defendant number. Your defendant number? 629. This court deems it appropriate to stay the execution of the order dated 14/8/2024, passed on I number 1. I number 1 and 2 till the is stayed till the next date of hearing. It is needless to observe that it is needless till the next date of hearing. They have to come. Let them come. They have to come, right? Yes. Issue merchant notice ಮಾಡಿದ್ದಾರಲ್ಲ. Liberty is reserved to the respondent plaintiff to seek for modification bar vacating of the interim order granted by this. Yes.
Serial number 12.
It's 540, Mr. Consul. What is this I-1 of 24? Who is going to object your applications now? Who is objecting your application? Serial number 12. Who is objecting? DP Mahesh. He has to be heard, Alva. He has to be heard. We will see then. Let him come on Wednesday. Dismissal order ಅಂತ ಮಾಡಿದ್ವಿ ಬೇಡ Wednesday ಹಾಕೊಳ್ಳಿ. And if on that day, first round, you have to come and tell the applications. ಯಾರು ಸತ್ತಿದ್ದಾರೆ ಅಂತ ಅಫಿಡವಿಟ್ ಹಾಕಿದೀರಾ that they have not died? You have to file an affidavit. You let him be present before the court. See, there is an order. You have to file an affidavit that they are alive. ಅಲ್ಲ alive ಅಂತ affidavit ಹಾಕಿದೀರಾ?